Yet, my lord, I have taken consent of other side, my lord. We need to file an additional affidavit, my lord.
Okay.
I am for the caveat.
By Jay Barwell on the council for the appellant, list on 30.
On 30, my lord.
Yeah.
Mass subject.
May I please?
Well, in item number, it's a series matter, my lord, item number 11 to 25.
Ah,
We are required to file an affidavit in reply, my lord.
yes.
My lord, we are filing the affidavit in reply today. Lordship, may I kindly take it up?
My lord, I appeal for the respondents in this matter. My lord, may it kindly be fixed for final hearing on 11th. My lord. There is some urgency because they are enjoying
11th of this.
11th of December. It can be. My lord.
Okay. Mr. D. Nuts, the senior governor advocate, appealing on behalf of the appellant, submits that he is filing affidavit reply within the course of the list the matter. Again on 11th, 11th December.
DPO, my lord.
Item 11 to
25, my lord.
yes.
May I please, Your Lordship? I beg to, with consent of the others, my lord, I beg to mention item number 5,
5.
Lordship.
Yes. What is this?
This is the, this matter may be fixed on 12th, my lord,
12th
12th
of December.
December,
You are appealing for
appellant,
appellant MS B. Bora.
Lordship.
On request made by MS B. Bora, learned counsel for the appellant. List now 12th
12th December.
12th December.
May it please, Your Lordship.
6, ma'am. Item 26, ma'am. I'm making a prayer on behalf of the council for the respondent, Mr. A. Goyal. He is under bereavement. We should make the matter be listed after a week. But I have taken concept of Mr. STK, the appeals for them.
Okay. SCKR.
26.
It is submitted that Mr. A. Goyal, learned counsel for the respondent is in bereavement. So accordingly list after 1 week.
Okay.
Yes, so
Yes, my lord, I beg to mention item number 3, Lordship.
Mm.
Here I have noticed in para number 3 and somewhere some mistakes are there.
Mm.
So I may be allowed to file an additional affidavit correcting those mistakes, Lordship.
okay. I'm not saying anything. I'm just adjourning. How much
Yes.
time you require?
Just let it be fair, placed again on 28, Lordship. Little urgency is there.
28.
Yes, Lordship.
28, there will be some difficulties.
29, Lordship.
Oh. 30.
Yes, Lordship.
On request
Deeply
by Mr. Som, and counsel for the petitioner. List on 30.
Lordship, regarding
November.
affidavit may be mentioned, Lordship. Otherwise,
Okay.
Mm.
MS Som, then counsel for the petition. Is permitted to file an affidavit, additional affidavit. Correcting
some mistake in the petition.
the mistakes in the PI. List again on 30.
I'm obliged. Deeply
I'm
obliged.
appearing in this matter. Correspondent number 1
MS
and Borderland.
and Badulal and council appears for the standing council.
Yes,
Which department?
Revenue Department.
Revenue department appears for respond number 1.
Lordship, I am appearing for respondent number 2, my lord.
And MS MD Bora, then a governor appears for respond.
Next.
May I please, Your Lordship?
Hmm.
With consent of the other segment, I beg to mention item number 9 and 11, madam.
9.
9 and 10, madam. In this case, madam, in record, madam, also when filing, madam, the writ appeal, madam, in the writ petition, some pages are missing, madam. So it is required to brought in record, to bring in record, madam.
You'll have to file an IA.
Yes, madam. Yes, madam. So matter will be fixed on 18th of December, madam.
Okay, on request made by SK Medi, learned counsel for the appellant, list on 18th December.
I'm appearing for the private respondents in item number
And Mr. PT Nair, learned counsel, appears for the private respondents
10. In item number 10.
in writ appeal 320/2023.
Lordship, I am appearing.
Deeply obliged.
I am appearing in item number 9 for the private respondents. My appearance may be recorded.
And
IDAS.
MS
IDAS.
IDAS, learned counsel appears for the private respondents In with appeal 265.
My lord, in only one, my lord, is some small prayer, my lord. In earlier occasion, on 6/11/2023, my lord, there's some small protection to the read appeal, my lord.
Give me the file.
Yes, my lord. That my lord, only one, it was my lord analogous method. Instead of analogous method, it should be depending before the execution court. That much, my lord.
Stay to be safe.
No, I'm not, paying stay, my lord. Nine. Only small, my lord, this.
What interim is given?
My lord. My lord, the order was my lord 6/11/2023, my lord. The last line, my lord, this Dr. Senior Counsel and Pedinar Counsel representing private respondent assured that they will not insist for taking
Ah.
up. Yes, only when this instead of analogous method, that should be like before the execution court coolaship, my lord. That much, my lord. Because the execution case is pending in before the coolaship district, my lord. That much, my lord. Quantum is, my lord, before the isolments, my lord. Up to 9.
My lord, my clients are in the contempt case, my lord. My learned defense clients most
Yes,
probably
ma'am.
would be.
Only that line. Analogous, instead of analogous, that's the execute before the execution court coolaship, my lord.
Okay, Mr. P.T. Nair, learned counsel. Representing the private respondents. Submits. That they shall not be insisting upon the contempt proceedings
As the,
pending in the result.
I saw.
NMS,
I does.
IDAS, learned counsel. For the private responders also assures that they will not be taking up the execution case.
execution case pending before the coolaship district,
Before the
coolaship district,
district court.
district court, madam, coolaship district.
District court. Coolaship district.
I am appearing for the respondent states.
M. Kalita, Learned Additional Advocate General appears for the state of Missouri.
18 of the December, highly obliged.
List on appeal.
May I please, your lordship? Your lordship, I'm praying for listing of a contempt case for orders
Orders, next month.
after 4th December.
8 December.
Much of.
Meet, please, your lordship.
But I beg to mention for listing of a writ appeal, my lord, fresh appeal, my lord. Any day, your lordship, please, yes, my lord.
When did you file it?
My lord, we filed it on 17/11, my lord. Any day, your lordship, please, yes, my lord. 6. Always.
May I please, your lordship? My lord, I beg to mention item number 33, my lord. My lord, respondents filed the affidavit in opposition, my lord. My lord, I need to file the reply, my lord. 2 weeks time may be granted, my lord.
Your good name, please.
TSK, my lord.
Mr. TSK, learned counsel for the petitioner. Praise for how much time?
My lord, 3 weeks, my lord.
3 weeks time to file reply to the application opposition filed by the respondent,
Respondents bank, my.
by the respondent bank.
My lord, interim order may be continued.
After 3 weeks, interim order passed early to continue. till the next.
Highly obliged, my lord.
Please, your lordship, may I pray for listing of an interlocutory application for condonation of delay in filing the connected writ appeal
When did you file?
on 20/11.
December. 8 December.
8 of it.
Item 1 for motion.
Lordship, this bail is filed against the issuance of IMFL wholesale license, my lord. IMFL warehouse, the wholesale license, my lord, without taking into consideration of the objection raised by the local people, my lord. Behind the back of the people, my lord, this license was issued, my lord. And after came to know, my lord, they obtained all the records, relevant records pertaining to issuance of this license, my lord.
1 minute. Yes.
No, my lord. On 2/6/2023, my lord, the license was issued, my lord. And the location of the proposed, my lord, warehouse, my lord, situated, my lord, within, there are schools, masjid as well as my lord, madrasas, my lord. Apart from this, my lord, the president of Gaon Panchayat, my lord, he has filed objection without obtaining his NOC, my lord. Without obtaining NOC from the local bodies, my lord, the 295 of the excise rule, my lord, provides that, my lord, objection from the, my lord, 295 of the rule, my lord.
Yes, what do you?
Lordship, the provision which my learned friend is relying upon regarding distance from educational institutions, schools, colleges, etc. That is only applicable to wine liquor shops here. This is a warehouse. From no sale of liquor is allowed.
Oh, this is a warehouse.
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 Your Lordship. And
No, my lord, 295, my lord.
secondly,
Give the rules. What rule is it?
My lord, 295 of Assam Excise Rules 2016, my lord. Objection from local bodies and from following persons, my lord. In case of corporation, municipal or town committee areas, the corporation or municipality. One. Page 171, man. This one. 171. 171 page, man.
Yes.
My lord, 295, objection from local bodies from following persons. In case of corporation, my lord, I'll skip to my lord, 2, my lord, Roman 2. In case of areas not situated in a corporation, municipality or town committee area, the panchayat concerned, the owners of occupiers and residents of neighborhood of the premises involved.
This is with regard to.
My lord, assertion.
you will find it at above
One
Rule
six-
294. The chapter starts above Rule 294. It is the chapter is ascertainment of public opinion regarding number and location of excise shops. Just above Rule 294, you're talking.
Just above rule.
294.
Page
Heading
169.
chapter is there. Page 169.
Oh, excise shops.
Your
This is a warehouse.
My lord.
Yes, then.
Number 295A also, my lord.
295 comes under this.
And
heading.
294, my lord, 294A. A is the shifting of premises license for wholesale or retail vend or foreign liquors, country spirits, so and so from location to another within the same district shall be allowed. So and
That
so.
is a different issue.
Now, my lord, admittedly, my lord, this is a the premises where the warehouse
This is with
license.
regard to warehouse. And this rule is with regard to the shops, liquor shops, correct?
Yes, yes.
Now, my lord, even
Because some people might have an objection to sale of liquor right next to their house. That is why this rule was incorporated.
This is a warehouse.
now, my lord, even 289, my lord, 289. Oh,
This is also liquor shops.
no, see, there is a provision, my lord, or any other intoxicant shall be granted now.
Where?
It 168, my lord. 168 page number, my lord.
Oh,
My lord, 289(2). No MFL, so and so owner's license shall be established municipality, so and so and so. Last 3 lines from this, my lord. No license for retail of sale liquid or any other intoxicant shall be granted at a site situated within so and so. So now, my lord, here is a case, my lord. They have obtained NOC from Anchalik Panchayat, my lord. I have produced the records, my lord.
issue is this.
My lord,
What they've issued is a warehouse license.
my lord.
This particular chapter deals with licensed shops.
So, my lord.
You prepare your case properly and come back.
Now, my lord,
Otherwise, we
now reports
can't entertain.
prior to issuance of the license.
Now, first thing you'll have to differentiate is what is warehouse and what is licensed shops.
That's true, my lord.
After that only you can
Now,
make
my
your
lord, in
arguments.
this case, prior to issuance of the license, my lord, the
License of what?
warehouse, my wholesale, Now, my lord, the excise inspector furnished a report which shows that by
Where
saying,
does the rule deal with warehouse?
oh, whereas my lord, 114, my lord, of the rule, my lord, provides for grant of wholesale ban of foreign liquor. 114, grant of wholesale ban of foreign liquor. License for wholesale ban of foreign liquor shall be granted by excise commissioner within previous sanction of the on payment of annual fees and assessments. Grant of license also for the license owner. This is for regarding license for the wholesale ban or shall be granted for a period of 3 years. Regarding license, grant of license, my lord, 114, it is silent, my lord. And this, my lord, 295.
That's why I'm saying.
My lord,
First, you'll have to differentiate what is warehouse and what
My
is a liquor shop.
my lord,
All right,
my lord.
then you come to the rules.
My lord.
Now, where does the rule provide that no license should be given to warehouse? Provided they are now so and so, so and so.
Now, my lord, as far as the rule is concerned, my lord, it's a rule of 2016 regarding issuance of, my lord, whereof wholesale license, my lord. This restriction, specifically the restriction imposed under 279, 289 is not there, my lord. These are for shops. Now, only thing, my lord, 295, my lord. 295, my lord, if 294A, my lord, going by 294A, 295, my lord, which shows that public opinions, my lord,
With regard to liquor shops,
now, my lord, as a whole, it starts from, my lord, 294 onwards, my lord.
see,
Shifting,
council, you are wasting this court's time. You study your case properly and come back.
my,
When do you want?
it was chapter 1,
On request made by J. Laskar.
my lord.
Then we come to for the petition. Case number 1.
Obliged.
Obliged.
I plead your lord. Lordship, non-consideration and non-disposal of this my complaint, my lord. Petitioners filed by this 13/3/23, that is page 12, annexure 1, my lord.
Yes.
My lord, respondent number 5, my lord, he is a government Gaura, my lord. He is public making a serious allegations, my lord.
Yes.
Yes, my lord.
What is this PIL about?
My lord, my representation may be considered or either notice may be issued, my lord.
Yes, Sharma.
My lord, now office of the chief minister has provided the application of the petitioner before the deputy commissioner, my lord. Now, may I pray, my lord, I may be allowed to take instruction from the deputy commissioner now, instead of issuing the petition.
Okay, heard Miss MS
L. Wajida, my lord.
L. Wadida. Let us counsel for the petition. Mr. D. K. Sharma, additional senior governor. Submits that the office of the chief minister has forwarded the application.
My lord, page 11,
Representation.
page 11.
Okay, cancel that part. D.K. Sharma, then the additional senior governor. Prays for some time to enable him to receive instructions from the deputy commissioner now with regard to the representation made by the petition.
Oblige, your lordship.
How much time?
2 weeks, my.
This.
No problem.
Item 4.
For respondent number 1, your lord. Indian Bank. The last petition.
None appears for the petitioner. List of 2 weeks.
On the last petition, they were supposed to withdraw the wakalatnama.
Where's Ganguly?
Otherwise, the matter has become infructuous because bank has already issued another sale notice.
Maybe they'll come here. None appears for petitioner. Mr. A. Sharma, M. Sharma.
M. Sarma, respondent number
Learned
one.
Counsel appears for the respondent number 1. List after 2 weeks.
Please, your lordship, I am for item number 4, lordship.
You are appearing for item 4.
I am appearing on behalf of S. Sharma. He has just informed me to adjourn the matter for the day. The former petitioner is not willing to do the case, lordship. He will file his wakalatnama.
Okay, MS.
M. Burman, lordship.
M. Barman. Learned Counsel appearing on behalf of
S. Sharma.
S. Sharma, Learned Counsel for the petition, Learned Counsel enters appearance for the, you are appearing for the petitioner.
Lordship.
Enters appearance for the petitioners. And press. Copy. And press for adjournment of the matter. Let's go. List after 1 week.
After vacation, lordship.
What vacation?
After winter vacation, lordship.
Let us see after 1 week you make your appearance, then we'll see.
Obliged, lordship.
Mr. M. Sharma, Learned Counsel express for respond.
For admission item 6 and 7.
What do you know this thing? It's a very narrow campus, the matter is, man. There was an advertisement for the post of stenographer in the district of Dhemaji, my lord. In the district of Dhemaji. Post of 2 stenographers.
Other side.
Other side is there. Government is there. Is it?
Who?
Bigo. My lord, so there was advertisement for these 2 posts, stenographer in the Deputy Commissioner office in Dhemaji. So in person to advertisement, my lord, these 2 petitioners appeared and they were selected and thereafter they were appointed. My lord, will kindly see the date of appointment is 2006. So we were doing the job. Subsequently, unsuccessful candidate came to the court and they said, how the appointments are being made? And this appointment is not in accordance with the rules. This is what they say. But advertisement doesn't stipulate the rules. It's just saying that this is what is required. Some type 90 speeds. So whatever the requirement, that we fulfill. They come up and they submit before the court that it is not in pursuant to the rule because this you have to qualify. Now this matter was heard by the learned single judge. And he said, no, they have been working. What it can be done, it is up to government. They can qualify it. They can qualify it. A chance would be given to them for that course. And ultimately, in pursuance to the order passed by learned single judge, the government issues an order to us. You qualify this particular. Accordingly, we qualified. After being qualified, in pursuance to court's order, again they came up before this court. And they said, no, how can you do it? This is because the order to be passed is by the commissioner. Deputy secretary has passed this order in person to High Court's order. A direction is given to the commissioner. So now the High Court says in a second round of litigation, again the government has to decide it. Now this time the government decides not to consider, they decided to go for a fresh advertisement. Now this was put to challenge before this court. And this is the petition we filed before the court and said, how can you do it? I work for so many years from 2006. There are judgments of the apex court also. Once you work, they should be allowed. So on the basis we argued, but the learned single judge turned down our argument and ultimately a judgment was passed by the learned single judge saying that there has to be re-advertisement for the post. That's why we have challenged it by an appeal. In the appeal, when it was moved, the order was passed protecting us. No, they have been working. This way the matter has come up before this court. So if your
Where is
lordship,
the- Where is the order?
now kindly see the first advertisement.
No, where's the order protecting you?
Yes,
Date?
yes, I'm saying protecting me. Kindly see the first order. My lord, the first kindly see the advertisement 49, then it will be clear 49. 49 is the advertisement. Kindly see the date 49, page 49 of Writ Appeal 326. Your lordship is 326.
Yes,
Now kindly see 49.
1 minute. Yes.
This is 4th of April 2007. Serial number 2. Name of the post, stenographer, number of post 2, educational quality 10+2, shorthand typing speed 80, so and so, so and so. So this is what it says. Now, but there was no suitable candidates in the person's advertisement. So they re-advertise at page 51. Kindly see 51. 27th of February, same advertisement. Kindly see on the first, applicants are invited in so and so, and Deputy Commissioner, Office Commissioner Dhemaji, number of posts 2. Must pass SLC examination, equivalent examination, recognized university or board, shorthand, speed, so and so, preference will be given, computer diploma and having knowledge of word processing. So this was in pursuance to that, my lord, we appeared, and accordingly at page 52, 17th of June 2008, we both were appointed. Kindly see, he is thereby appointed as stenographer underqualified, because that was not a part of the advertisement which we have to qualify. So here against a sanctioned post. Now my lord will see at page 54, this was put to challenge by few candidates. And if your lordship sees paragraph 50, page 58, the last paragraph, third paragraph, page 58, third paragraph. Although the Deputy Commissioner Dhemaji, pursuant to selection, sought for due approval.
There's no third, page 58.
58. The judgment starts from the first round of litigation. Page 54. 54 it starts. 54 judgment starts, and this is challenged by 5 candidates put to challenge my appointment. Page 58. Kindly see the last paragraph, 58. 58. What you got it? 58.
58B.
58B, yes. Although the Deputy Commissioner Dhemaji, pursuant to selection, sought for due approval of Commissioner and Secretary General Administrative Department, but before any response was shown, response number 5 and 6 were appointed. There is no requirement of seeking such approval as a provision of rule. In one hand, the case of the petitioner is that since the response number 5 and 6 did not conform to the requirement of the rules, their candidature ought to have been rejected and consequently could not have been selected. But on the other hand, the stand of the respondent of 5 and 6 is that they have offered their candidature in terms of the advertisement, and the same having been accepted, they duly participated in the selection. In one hand, the contention is for strict application of the rules, and on the other hand, the contention is for deemed relaxation or actual relaxation of the rules. It is also submitted, since the respondent of 5 and 6 have been appointed as stenographer underqualified in the lower scale of pay, same by itself may not disturb the post of stenographer grade 3. Now, this paragraph is important. Although the above aspect of the matter will require consideration of Commissioner and Secretary of Government of Assam in General Administration B Department, accordingly, this writ petition is disposed of, directing the said authority to examine the matter in the light of discussion made above, material available on record, pass appropriate order as may be expedient in law. Now, my lord will kindly note down. While taking action in terms of this order, the authority may also consider whether in the meantime the two respondents have acquired the required qualification and or whether they should be given opportunity to acquire the same. This was the order passed. This order was never put to challenge before any appellate court by the government. Now, after this, at page 60, next page, 16th of December 2011, this order has been passed by Deputy Secretary to the Government of Assam. Now, my lord will kindly say read petition mention. With reference to your letter, I am direct to say that in persons of the Honorable Guwahati High Court, order dated 16/6/2011, considering the services already rendered by both of them, the respondent 5 and 6, namely so and so, may be given opportunity for acquiring requisite qualification within time frame for the post of stenographer 3 as envisages as prescribed in Schedule 1, Part A, Rule 8, Assam Stenographer Service Rule 1995. Accordingly, my lord, at page 63, my lord, 63, we acquired and we got this certificate. Kindly see, Provisional National Trade Certificate, so and so, Training and Industrial Training Institute. So we cleared. Government, my High Court says that you may give an opportunity. Government has given opportunity, accordingly we cleared that test. So there is 2 certificates, page 63 and 164, the two appellants. Now this, my lord, when we cleared in person High Court's order, you may, and they have issued orders, we went and cleared. Now again a writ petition has been filed. Second round of litigation at page 65. Now kindly see the order passed by this court at page 67. The last paragraph. I have heard on the council parties, the order dated 16/6 passed in review has clearly spelled out the various points respondent to has to consider while examining the case of respondent 6 and 7. However, on perusal of the order dated 16/12/2011, passed by Deputy Secretary Government of Assam, I find the issue raised by this court in the earlier writ petition has not been considered and no findings have been made in this respect. Accordingly, I find a letter dated 16/12/2011 is cryptic. The said letter dated is accordingly set aside. Respondent is directed to consider all points raised by this court in his order dated 16/6/2011 passed in writ petition. Come to a finding by giving reasons. Respondent number 2 will thereafter take a decision on the selection appointment private respondent. Entire exercise will be carried out within a period of 6 weeks from the date of receipt of the certificate. Now the only what they are saying that is not compliance fully. They are saying that Deputy Secretary Commissioner should have passed the order because direction was given in the first round of litigation to the Commission. But the order which was communicated to us, if your Lordship kindly see at page 659, page 59B, kindly see 59B.
Yes.
All aspect will require consideration of the Commissioner Secretary Government of Assam in the General Administration B Department. Accordingly, this has been disposed of directors said to examine the matter in the light of discussion made over material available on so and so. While taking action in terms of his order, authority may consider whether in the meantime the 2 respondents have acquired the required qualification and or whether they should be given opportunity to acquire the same. That's all, my lord. Where is the question? Now at page 60, that opportunity was given by whom? By the General Administration B Department. Kindly see on the top, page 60. Now, all the time, Commissioner doesn't give an order. It is by a lower one, Deputy Secretary in pursuance. Kindly see a subject, WPC 3197. So, in pursuance of High Court's order, they have given opportunity. I cleared. But second round of litigation, the court said, no, it is not in pursuance of the court's order. Now, this, when it was again sent back to the government, by second round of litigation, at page 69, this we put to challenge, 69.
Yes.
Now kindly see, my lord. 18th of August 2016, they referred to the order, second round of litigation. Kindly see page 70. 70. Bottom, my lord. Now, therefore, in consideration of the rules governing the recruitment of stenographers, matter is disposed of by directing the Deputy Commissioner Dhemaji to consider scrapping the earlier irregular recruitment process and to consider issue of advertisement afresh to fill up the post of stenographer 3 as per laid down in Assam Stenographer Service Rule after obtaining fresh approval from the government so and so towards filling up the vacant post. So this order was put to challenge. Now this time, when it went to the government in person to second round of litigation, government said, no, what we'll do it, we'll go for re-advertisement for the post. But by the time we qualified in person, so High Court's order, and they did not challenge, state did not challenge. No, this order is not proper. We are not accepting this order. We prefer an appeal. That also has not been done. Government said that you go for in person to High Court's order. So where are all this? Where is the question of this?
But then that letter was set aside,
Which letter?
1611,
That's-
16,
Which-
16:6.
Yes, of course. 16.6 order was set aside.
Oh.
16.6 order was set. That's why we challenge it, my lord. We challenge that. We challenge all.
No,
16 December 2011 was set aside by the High Court in the second round of litigation.
Hmm.
Second round of litigation, 16th of December at page 60 was set aside. 1612 at page 60.
But by that time, we have acquired the qualification.
My lord, kindly note down 16th of December 2011.
Yes.
This order was set aside. My lord, when it was set aside, kindly note down, my lord.
1 minute.
This order was set aside. My lord, 31-5. This order was set aside by this court 31-5-2016 at page 65.
Correct.
And when we acquired the certificate, kindly see at page 62.
Okay.
16th of December 2011. Kindly see at page 62. One, right?
31-7.
31-7 at page
64
64.
below.
Below, kindly see, my lord. 31-7-2014. At page 64. Are we at that one? Bonali. My lord, kindly see page 63 first. I acquired a degree in pursuance to High Court's order at page 63 down below. Certificate 2012-2013. Lordship got it?
Mm.
Now, second page. 31-7-2014. I acquired already.
Mm.
And the court set aside on 31-5-2016 after acquiring it. So, these certificates are with me. In the advertisement, it doesn't mention all this. When they come to the court, unsuccessful candidate comes to the court, no, these rules are not being adhered to it. Because we said the advertisement doesn't stipulates. Now, this degree which I acquired is prior to set aside by this court on 31-5-2016 at page 65. When it sends back to the government for again fresh consideration, government this time says that no, what we'll do it, we'll go for re-advertisement, that's which I've read. This was put to challenge before this court by way of a writ petition at page 74.
Court protected us.
Initially, the court protected us in order to accept. At page 74 is my lord, the writ petition which we move against that. And our case at page 91 is the prayer. 91 is the prayer. Kindly see 91.
Yes.
A writ of nature of searches should not be issued, set aside and quash the impugn order bearing dated 18/8/2016 as issued by Commissioner Secretary so and so regarding direction Interior Deputy Commissioner so and so 92 FRS so and so written nature so and so. So this prayer we made before this court and accordingly we asked for stay of this order and accordingly on 16/11/2016 there was an interim order which was passed by this court. 16/11 in this WPC. You just give one copy I have. Just see the order minus 16/11. 16/11/2016. When we moved this petition before this court, and this is a prayer, there was an interim order passed by this court. Toward I am working, it was not been disturbed. Kindly see the interim order which was passed in 2016. Last stay of this, it was stayed.
Yes.
Now thereafter, a judgment is being passed after hearing the parties at page 39. Page 39 is the judgment of the learned single judge. And at page 164, it starts from the judgment starts from page 137. And kindly see at page all the discussions were made from page 31, what was the contention. Ultimately, the last portion at page 165, at para 34.
Page
165. Last paragraph. In view of the discussion of both the writ petitions, appointing authority Deputy Commissioner Dhemaji may proceed with the selection process to fill up the resultant vacancy in the post of stenographer grade 3 in his establishment in accordance with the extant rules and procedure, if so advised. If in such process there is participation or the petition or private respondent, appointing authority shall consider about grant of age relaxation under the extant rule provision. So, my lord, the government where advertisement which was issued, that was kept by the court and saying that the private parties will get the opportunity of participating in it. So this order was put to challenge by way of an appeal which is before this court. This is the position of the case, my lord. Now the issue, the points for consideration before by my lord is the length of service which I continued from 2006, 6 or 7, 2008 till 2023, and I have not been disturbed. Should now the Honorable Court should upset my appointment. This is number one. Should my appointment be upset in 2023? That's number one. I worked. Number two points for consideration is that in the first round of litigation, it is the order of this court. It is the order of this court that preference was given to the government. Either you allow to go it for this to complete this course, and in pursuance to that, government already has given me that opportunity. And accordingly, before the order passed by the second round of litigation, I already acquired the degree, the certificate. Whether at this juncture, whether I should be upset, because they did not prefer any appeal against the order passed by the learned single judge. First. And setting aside by this court in the second round of litigation was afterwards. But in the meantime, I qualified and I got the certificate. So whether I should be disturbed. This is the point. Now, to this, how the apex court has dealt, the length of service, whether an employee should get protected or the court should not disturb at this moment because of the length of service which they continue. Equity has to be looked into it, whether equity can override the law that has been made, depending on the length of service. I'll just place, my lord, some few decisions of the Supreme Court in this context, my lord, which will make easier to your lordship.
Before you go to that, let us see the findings of the learned
single judge. Yes. Finding starts 13.
Para 13.
13, 1-3. 1-3, page 150.
Yes.
At this stage, it is opposite to refer to the provision of Assam Stenographer Service Rule 1995, a set of rules framed in exercise of the powers conferred on the proviso to Article 309 of the Constitution for purpose of regulating recruitment and the condition of service of the person appointed to the Assam Stenographer Service. In the definition clause, Rule 2A of the Assam Stenographer Service Rule 1995 has defined appointing authority. An appointing authority inter alia means the head of department, deputy commissioner, or the other heads of offices, as the case may be, in respect of stenographers, grade 2 and grade 3 in the respective offices. Cadre and status as provided in Rule 3.1 therefore includes stenographer grade 3. As per Rule 3.2, stenographer grade 3 appointed in others state government offices shall be deemed to constitute separate cadres in the respective grades in respect of each such office. The method of recruitment, various cadres, including stenographers grade 3, have been outlined in rule, and as per Rule 5, the method of recruitment, the cadre of stenographer grade 3 is direct recruitment in accordance with the provision of Rule 6 and Schedule 1, Part A. Rule 6.1 has stated the appointment of the cadre of stenographer grade 3 shall be made by direct recruitment in accordance with the procedure as provided in the said rule. Selection is to be made in accordance with the scheme of selection as given in Schedule 2 or as prescribed by the government. As per Rule 8, the academic qualification of a candidate for appointment to each cadre shall be prescribed by the government from time to time. Qualification experience have been prescribed in Schedule 1, Part A and Part B, and Schedule 1, Part A reads as follows. So these are the qualification, my lord, which was given. My lord, let us put it this way. It is an admitted fact, my lord, it is an admitted fact that there is a rule. Let us put it this way, there is a rule. You have to qualify as per the rules. In the advertisement, it was not mentioned as per the rules. Learned Singhal just say, no, whatever may be, it may not be. But question of recruitment is as per Rule 6. Qualification is prescribed, Rule 8. This is what the Learned Singhal just says. Now, the fact is that I can't deny, my lord, I can't deny that while I applied and interview was taken, my appointment is not based on this particular specific rules, because in the advertisement it was not mentioned. But a chance was given because they appointed and it says underqualified. But when they challenged it, the Learned Singhal just has given that option to the government. Either the government should have said, sorry, we are not giving you any options. Your appointment is not in accordance with rule. You can't go, because that option was given by the Learned Singhal judge. And they have given an option to me by issuing a letter, you can go ahead. This is what I am saying. Admittedly, my lord, it is not in accordance with the rule, but an option was given. Relaxation was given by the government. Now at page 152, kindly see para 15. 17, kindly skip 17, my lord. The office member, 17, 153. The office memorandum dated 2/9/1998 of the Personnel Department, Government of Assam is on the subject. Appointment of underqualified stenographer in the state government, semi-government organization. By the office memorandum, attention has been drawn to the instruction issued earlier by the office memorandum dated 6/7/1978 and 2/5/1981 to mention that instances has come to the notice of the state government that in spite of instruction issued by the government, the practice of engaging underqualified stenographers was being continued by some department. By the office memorandum dated 2/9/1998, government has reiterated its earlier decision and cautioned all concerned not to engage underqualified stenographer, with the consequent action of holding the appointment authority responsible in the event of appointment of underqualified stenographer. By the office memorandum, the state government has emphasized that the appointing authority shall not appoint underqualified stenographer. It is settled that the omission to mention the relevant qualification does not relieve the state government or the appointing authority under state from its obligation to follow the existing rule, which in the case in hand are the Assam Stenographer Service Rule 1995 and so 2005. State and its authority are bound by the standard specified in the extant rules, and they cannot extricate themselves from the obligation of enforcing the extant rules. At the cost of repetition, it needs mention. Advertisement dated so and so was published in order to fill up 2 vacancies of stenographer, which pay scale is meant for stenographer grade 3, which the qualification prescribed in the Assam Stenographer Service Rule 1995. A look at the orders of appointment dated goes to show private respondent has been appointed as stenographer underqualified against the two sanctioned posts of stenographer, and a private respondent were given a lower pay scale. Deputy Commissioner Dhemaji, as the appointing authority for the post of the said two posts of stenographer, has not provided any explanation as to why two private respondents has been appointed as stenographer underqualified when the advertisement was specific that the application invited for filling up the post of stenographer with different pay scale as noted above. Thus, it is clear that the Deputy Commissioner Dhemaji, as the appointing authority, did not follow the procedure in giving appointments to the private respondent. A submission had been advanced on behalf of the private respondent that the advertisement dated 27/2/2008 did not mention about the qualification, etc. in conformity with Schedule 1, Part A of the Assam Stenographer Service Rule 1995, and thus no role could be attributed to the private respondent in the act of their being appointed as stenographer underqualified by the orders of the appointment dated 17/6/2008. It has also been urged on behalf of the private respondent that considering the long years of service, they have extended as stenographer underqualified since the year 2008, and also the fact they have acquired the requisite qualification as per the Assam Stenographer Service Rule 1995. In the meantime, no interference would be made at this distance point of time. The advertisement was published on 27/2/2008. Appointments were made by the orders of the appointment dated 17/6/2008. Immediately thereafter, the petitioner and a number of candidates who participate in the same selection process alleging commission of illegality in the selection process has approached in the court by a writ petition 3197/2008. From the order dated 16/6/2011 passed in writ petition, it is noticed similar plea on behalf of the private respondent were taken with the submission that on the date of final consideration of writ petition, they have already gathered experience of 3 years as stenographer underqualified. It is not denied at this stage by the private respondent they did not possess the requisite national trade certificate laid down in Assam Stenographer Service Rule either at the time of submission of candidature in response to the advertisement or at the time of their appointment on 17/6/2008. Is a settled position of law. Eligibility of candidate applicant for a public cost or service is to be adjusted as on the last date of receipt of application for such post or service in terms of relevant advertisement and the prevailing service rule. The Honorable Supreme Court in 3 judges, so and so, this law has been laid down. At page 156, my lord, another judgment was cited at page 20, para 22. These are all judgment of the Supreme Court. All the judgment of the Supreme Court. Now, my lord, at page 163, after discussing all the matters and citing the judgment of the Supreme Court, at page 162, 161, para 29. Para 29. It is to be noted that the selection process, there were number of qualified candidates fulfilling the eligibility criteria laid down for the post of stenographer in the Assam Stenographer Service Rule 1995. And as such, it is not a case where there were no qualified candidates. Since the communication of the Deputy Commissioner, Government of Assam GAD has already been set aside by the order passed in so as a result, observation made therein stood effaced, and therefore no dilation is necessary to be made in that regard. The impugned order dated 18/8/2016 has clearly observed entire recruitment process to be initiated, and a direction has been made to Deputy Commissioner to consider scrapping the recruitment process and consider issuance of an advertisement afresh to fill up the post of stenographer grade 3 as per the norms laid down in Assam Stenographer Service Rule 1995. After obtaining fresh approval from the concerned department of the government, it has also been observed while undertaking the fresh recruitment process, Deputy Commissioner Dhemaji, as the appointing authority, would examine whether the applicant, including the 2 respondents, have acquired the required qualification or not. Though it is canvassed, Commissioner and Secretary to the Government of Assam has not many observations in express terms. It is evident to the state authority by observing that the Deputy Commissioner Dhemaji, as the appointing authority, would also examine as whether the private respondent acquired the required qualification in the meantime, has by clear implication refused to exercise the power of election under Rule 25 of the Assam Stenographer Service Rule in favor of the private respondent. A reading of the order dated 18/8/2016 goes to imply that due consideration is given to relevant factors required to be taken into consideration. And this court has not found any good and sufficient reason to hold that the impugned order dated 18/8/2016 is inconcurrent in any manner to the direction made by this court in its order dated 16/6/2011, order dated 18/8/2016, whereby direction has been given to scrap the earlier selection process, which culminated with the orders of appointment dated 17/6/2008, is found just, proper, and conformity with the law for the reason already discussed herein above. Cost of repetition, the court it reiterates that a person who does not possess the requisite qualification laid down by the post of so and so by governing the Assam at the time selection process cannot be appointed to the post of stenographer, and as a such appointment would be contrary rules and void in law. Subsequent acquisition of prescribed qualification cannot be cured at any stage. Continuation of such appointment would be illegal. So that's the basic where the learned single judge has decided that this is not in accordance with the rules, your appointment. We said that no, it is not a part of the advertisement. We said that already there was an order passed by learned single judge. In pursuant to that single judge order, he qualified. But that what the learned single, that cannot cure your particular qualification. That's what the learned single judge has observed. And my lord, he upheld the order that has been passed by the state government. So thereby we have to participate in advertisement. So this 2008 and 2023, my lord. And all the time we were getting benefit of the court's order and we are continuing in the service. At this stage, whether we should be disturbed or not. In view of some rules is also there. In what manner the court decides, the Supreme Court, whether it should be disturbed or not at this stage. I'll show, my lord. Well, I think that's the judgment of the learned single judge, my lord. Kindly see first 1993, my lord. 1993, 3 SCC page 591. Gupta, so 2 copies. (1993) 3 SCC page 591. Paragraph 6. 6 months. Since we find that it was default on the part of the second respondent, the director of education in illegally approving the appointment of the first respondent in 1981. Although he did not have the requisite academic qualification, kindly note down, man. And as a result of which the first respondent continued to hold the said post for the last 12 years now, it would be inadvisable to disturb him from the said post at a later stage, particularly when he was not at fault when his selection was made. There is nothing on record to show that he had at that time projected his qualification other than what he possessed. Same as like us, Smilo. If, therefore, in spite of placing all his cards before the selection committee, the selection committee for reasons or other had sought it fit to choose him for the post and the second respondent had chosen to acquiesce in the appointment, it would be iniquitous to make him suffer for the same now. Illegality, if any, was committed by the selection committee and the second respondent. They are alone to be blamed for the same. I think this is the most fitted case. It is not in accordance illegally approving, which the learned single judge also say that how there can be an appointment. Now what the Supreme Court said, requisite academic qualification. Can you see once again, my lord, in page paragraph 6 on the next page, illegally approving the appointment of the first respondent 1981, although he did not have requisite academic qualification. As a result of which the first has continued to hold the said post. But my lord, my requisite qualification I have obtained after the court's order. Here is absolutely a case where there is no requisite qualification, even he continues.
Then the court said, the apex court said, it's not the fault of the candidate, it's a fault where the selection committee has appointed him. My case is a bit of better in this case. By that time I acquired in person to High Court's order. This is one, my lord, one judgment of this court, of the Supreme Court. Now, I'll show another judgment. Next case. Now, 2010. (2010) 5 SCC, page 136. Paragraph 19. Para 19 and 20. These two paragraphs. 19. It is evident from the above that in ex-serviceman general category, the last two candidates, namely Subhash Chandra and Taket Singh, has scored only 25 marks. Subhash Singh and Veerbhan, selected the ex-serviceman category, has however scored more marks than Subhash Chandra and Taket Singh. Subhash Singh and Veerbhan could and indeed ought to have been selected against the vacancy in ex-serviceman general category as per their merit. This, in other words, would require the select list to be recast and candidates suitably shifted from the reserve category to general category, in which even appointments can be offered to other candidate in the ex-serviceman BCB category, depending on the merit. Now, my lord will note down. Such an exercise, long after the selection process was completed, may unsettle the settled position and lead to removal of candidates who stand already selected and who have been serving for a long time after undergoing the prescribed training. This may also mean candidates who have accepted the result of the selection and may even have become overage may have to be brought in. We do not see any compelling reason for us to adopt that course at a distant point of time, especially when the same would upset what stands settled for a long time. Now, my lord will kindly see at para 20, last 4 lines, para 20. The last 3 lines, the appointment shall for all purpose be treated as a first appointment, subject to condition the company authority shall be free to direct appellant shall undergo the training afresh or take a refresher course of such training if deemed fit. My lord, they did not went also. Somebody challenged saying that no, merit list we are above, how it can be selected. This was put to challenge. It went to the apex court. Court said that they have served long back. Please do not disturb them. It will unsettle the settled. So even the court said that don't disturb, and the court further directed that they should be sent undergo for training afresh. So my case is much more better. It's the government who has sent me. I have in person the High Court's order. So this is one judgment, my lord. Second. Third is the one. Third, my lord, 2013, 14 SCC, page 494. SCC 494. Para 20. It is brought to our notice that in view of the interim order passed by learned single judge, the appellant have now completed a training and have been in service for more than 3 years. Therefore, the only question which survives for consideration decision is whether, after having undergone training and assumed charge at the place of posting, 26 appellants to be ousted from the service on the basis of cancellation of their appointment the revised merit list. This was the issue. Kindly see at 22 now. 22. This was the issue which was brought by an interim order. They ordered completed training. Para 22. The pristine maxim of so-and-so, fraud and justice never dwell together, has never lost its temper over the centuries and in continues to dwell in spirit and body of service to jurisprudence. It is settled law that no legal right in respect of appointment to a said post vests in a candidate who has obtained the employment of fraud, mischief, misrepresentation, or malafide. This paragraph next is important. It is also settled law that a person appointed erroneously on a post must not reap the benefits of wrongful appointment, jeopardizing the interest of the meritorious and worthy candidates. However, in cases where a wrongful or irregular appointment is made without any mistake on the part of the appointee, and upon discovery of such error or irregularity, the appointee is terminated, the court has taken a sympathetic view in the light of various factors, including bona fide of the candidate in such appointment and length of service of the candidate after such appointment. I think this also, my lord, will have a bearing on the present case. And only one last judgment on the equity. This, I think, these are direct, my lord, on my case, which I have shown, my lord, how the apex court dealt. Even in, suppose there is a rule also, he continues. Now there is judgment that he goes for training. My case is much more better. I have gone training before, while they set aside by division, by the single bench. Kindly see how court dealt with equity, my lord. At page, this is 1982 3 SCC, page 331, paragraph 6. I'll just not read trouble the whole last line. We adhere to our view. Lordship got it? Last line of paragraph 6, if Lordship turn to next page, 336. We adhere to our view after meticulously examining the learned comment. Having noted the criticism, we still adhere to the view that legal formalities cannot be enforced divorced from the realities of the fact situation of the case. While administrating law, it is to be tempered with equity, and the equitable situation demands, after setting right, the legal formulation not to take it to a logical end. This court would be failing its duty if it does not notice equitable consideration and mold the final order in exercise of extraordinary jurisdiction. Any other approach would render this court a normal court of appeal, which is not. So equity has to be also looked into it, man. This is what the apex court has said. Sometimes it overrides the legal position in view of the length of service which has been continued. And Lordship has seen all the judgment of the Supreme Court makes it very clear. So my humble submission before Lordship is that the judgment, with great respect to learned single judge, would be set aside on the ground of the judgment which has been laid down by the apex court. My length of service which I continued from 2008, not a single break. Throughout, there was an interim order which was passed by this court. I continued from 2008 till 2023 today. And today, if it is upset, settled will be unsettled, settled will be unsettled. So let me continue in view of the apex court judgment. By that time, the position would be different if I would not have qualified. I qualified. The Lordship has seen the judgment of the apex court. There are few judgments the Supreme Court say that no, let them go for training courses. After that, it was they were said. My case is much more better. I have gone for that certificate I acquired. So let me continue, my lord, with this. And these are, my lord, stenographers. So why at this stage it should be upset from 2008, 2023. So this is my humble submission for Lordship. If anything is there, I will definitely clarify. Let my learned friend give a reply to my submission which I have made before this court.
I appear for the respondent number 1, madam. Here, my lord, I would like to bring to your lordship notice to the advertisement part.
1 minute. You are appealing for?
Well, the GAD department. The respondent number 1, 2, and 3.
How about respondent five?
Respondent five, my lord.
Yeah.
And this item 7, it has been prepared by the respondent 5. There are 2 cases. Second one has been prepared by the respondent 5.
The advertising question is at page 23, page 51. Yes, page 51. One thing, my lord, admittedly, my lord, this particular qualification of having the national certificate, trade certificate, it's not mentioned in the particular advertisement in question. But my lord, in the appointment letter, page 52, next page, lordship may kindly see. This appointment letter was issued on 17th of June 2008. Here, my lord, in the appointment letter itself, it has been mentioned in the third line. Is hereby appointed as stenographer within bracket underqualified. Though the, my lord, selection was held for the post of stenographer, but while making the appointment, it has been mentioned as underqualified. So there is no such thing as stenographer underqualified. Now, my lord, challenging this particular appointment, the private respondents herein, my lord, in the present writ appeal, they preferred a writ petition at page 54, which has already been brought to notice of this honorable court. But one thing, my lord, 2 or 3 paragraphs of the judgment, my lord, I would like to point out. Page 56. Page 56, my lord.
Yes.
The third para, the Commissioner Secretary, General Administrative B Department, lordship has got it, my lord.
Yes.
By his letter dated 1/8/2008, addressed to the Deputy Commissioner Dhemaji, requested not to make any appointment of the selected candidates if they were found to be not eligible as per the relevant rules. Prior to that, Deputy Commissioner Dhemaji, by his letter dated 2/5/2008 and 2/6/2008, sought for approval of the select list. My lord, the rule also, my lord, is very categorically states that, my lord, after the selection is held, my lord, the list will have to be approved by the government. Here, my lord, this the government will be here, my lord. It is the General Administrative Department. They, by this letter dated 1/8/2008, strictly at that point of time itself, instructed the Deputy Commissioner not to make any appointment if this particular selection was not made in pursuant to the rules. Now, this particular document 1/8/2008 was not part of the, my lord, pleadings before the learned single judge. So the division bench directed us to file an affidavit by bringing this particular letter on record. We have filed an affidavit and, my lord, it is part of the record. Lordship will find it at page 170. In the affidavit that we have filed in the affidavit. 170. It is, my lord, dated 1/8/2008. It is addressed to the Deputy Commissioner from, my lord, the Undersecretary Government of Assam, General Administrative Department. Here, may I, my lord, submit? And also, lordship, may I kindly have a look at the reference letters, my lord. Letter is dated 2/6/2008. And other is, my lord, 9/6/2008. These 2 letters are, my lord, prior to the appointments being issued. Now, my lord, the content of the letter is, with reference to your letters quoted above, I am directed to say that as per the Assam Stenographer Service Rules 1995, the qualification for direct recruitment to the stenographer grade 3 has been prescribed in Schedule 1, Part A, Rule 8. You were therefore requested not to make, the direct embargo has been given, requested not to make appointment of the selected candidate if they are found to be not eligible for the stenographer post under the relevant rules, and make a fresh selection from amongst the eligible applicants. So, the government, my lord, who is the authority who was supposed to, my lord, give approval to the select list, already instructed the Deputy Commissioner way back in, my lord, August 2008, not to make any appointment towards the rules, and to complete the selection afresh with the eligible applicants who has got this, who fulfill the, my lord, required qualification prescribed in the rules. But despite that, my lord, the matter continued. And my lord, the private respondents herein, my lord, they preferred a writ petition in 2008 itself, immediately after the appointments were made. Now, finally, this honorable court, Lordship will turn to my lord page 59. This has been already read out, my lord, but I would like to, my lord, read it again. All the above aspects of the matter will require consideration of the Commissioner Secretary to Government of Assam in the General Administrative Department. Accordingly, this writ petition is disposed of, directing the said authority to examine the matter in the light of the discussions made above and materials available on record, and to pass appropriate orders as may be expedient in law. While taking action in terms of this order, authority may also consider whether in the meantime, my lord, the two respondents have acquired the required qualification, and or whether they should be given opportunity to acquire the same. So additionally, Honorable Court observed that, my lord, the authority should also consider whether in the meantime they have got the qualification, or if not, whether they should be given an opportunity to acquire the qualification. Now, my lord, pursuant to this order, this order is dated, my lord, 16/6/2011. Now at page 60, Lordship will find one communication. That is 16th of December 2011. And he says that, my lord, in pursuance of the Honorable Court's order, it is 16/6/2011. And considering the service already rendered by both of them, the respondent 5 and 6, namely so and so, may be given an opportunity of acquiring requisite qualification within the time frame for the post of stenographer grade 3 as envisaged and prescribed in Schedule 1 Part A, Rule 8, Assam Stenographer Service Rule 995. Now, this ought to have been in the form of a speaking order, but this is a communication which was passed pursuant to the order passed by this Honorable Court. Again, this particular order was put to challenge by the private respondents of the present appeal. That Lordship will find that page 65. Here, Lordship will kindly see the, my lord, WPC number, the year in which the writ petition was preferred. It is in 2012. And this order was passed in December 2011. Now, before that, Lordship will see, my lord, two certificates have been placed by the petitioners, stating that they have, in the meantime, before passing of the second order in the second writ petition, they have acquired the qualification. But, my lord, the writ petition was preferred in 2012 itself, challenging this order of the General Administrative Department at page 60. 16 December 2011. This was put to challenge in 2012 itself. Now, in page 63, Lordship will see when the petitioner, appellant hearing, they acquired the qualification, the date. 63 is one of the lead appellant, it is appellant number 1. She acquired the qualification on 2012-2013. After the second writ petition was preferred, challenging the order at page 60. And in page 64, the second appellant got the certificate on 31/7/2014. After the writ petitions were preferred, challenging the same. And finally, in 2016, the Honorable Court reverted back the entire matter, stating that, my lord, it was the government who was supposed to pass a speaking order. And this order at page 60 is not in the form of a speaking order. There is no such decision reflected in that particular letter. It's just a mere communication. So, my lord, that order at page 60 was interfered with. So that, my lord, submission has been now has been advanced from the appellants that, my lord, they were given the liberty to acquire the qualification by the government. It has been interfered with. That letter no more exists as on date. By the order of this Honorable Court at page 65, that is 31/5/2016, passed in WPC 590 of 2012. So that submission, my lord, made by before this Honorable Court will, my lord, hold no ground at all, because it has been interfered with, and that order has not been challenged by the present writ appellants at that point of time. Now, pursuant to the second order passed by this Honorable Court by the single judge in the second writ petition, finally a speaking order was passed. A detailed speaking order at page 69. That is 18th of August 2016. Whereby it was directed, my lord, that the selection should be cancelled and a fresh my lord selection should be undertaken. That my lord page 70. Last para. Now, therefore, in consideration of the rules governing the recruitment of stenographers, the matter is disposed of by directing the Deputy Commissioner Dhemaji to consider scrapping the earlier irregular recruitment process and to consider issue of advertisement afresh to fill up the post of stenographer grade 3 as per laid down norms in the Assam Stenographer Service Rules 1995. After obtaining fresh approval from the Government Finance SIU Department, General Administrative Department, towards filling up of vacant sanction post only. Now, this particular order was again challenged by the lead appellant. Now, my lord, in the writ petitions, in the subsequent last writ petition, the third batch of writ petition, we have prepared my lord, we have filed one, my lord, affidavit in opposition, where we have indicated the mind of the government that, my lord, this particular selection is bad in law. So, the picking order should be upheld on the ground that, my lord, the entire selection was held pursuant to the rules, my lord. And finally, my lord, the impugned order has been passed, which is under challenge before the Honorable Court by the line of single judge. After hearing all the parties, here, my lord, in para 29, my lord, this has been already read out by the appellants. But I would like to, my lord, read it again. Para 29, my lord, page 161.
Yes.
Says, it is to be noted that in the selection process, there were a number of qualified candidates fulfilling the eligibility criteria laid down for the post of stenographer grade 3 in the Assam Stenographer Service Rules 995. And as such, it is not a case where there were no qualified candidates. In fact, my lord, the private respondents who are parties in the present, my lord, writ appeal. And similarly, other persons were there, my lord, who were otherwise, my lord, qualified. They had that particular qualification or that diploma or degree, whatever is prescribed in the rules. But instead of selecting them, the present, my lord, the appellants were selected, who admittedly were underqualified. In the appointment letter, it has been mentioned as underqualified along with the post stenographer. So, my lord, whether a selection which has been apparently held dehones the rules, whether, my lord, that selection will sustain or not. Merely because, my lord, they have now acquired the degree, that diploma or degree, whatever is required as per the rules. Subsequent to, my lord, their appointment, whether they can be allowed to continue or not. Well, that's the entire issue. Only in 2013, end of 2013 and in 2014, the two appellants, they got the particular certificate while they were serving in, my lord, the office of the Deputy Commissioner. On the day of selection, my lord, they did not have that qualification. It's a settled law that on the last date of selection or submission of application, one must have that, my lord, minimum qualification. And, my lord, the minimum qualification prescribed in the rules cannot be relaxed, my lord. It is not a, it will not come under the relaxation provision, my lord. Minimum qualification cannot be relaxed.
Yes.
In fact, my lord, one notification of the government has also been brought to the Honorable Court's notice at page 134, which was issued in 1988. Where it has been categorically prescribed not to appoint any stenographer who is underqualified. 134. And, my lord, regarding the approval of the government here the government instead of approving the select list, on the contrary directed that my lord, the entire selection should be scrapped. And my lord, as per the rule, the selection should be held. That 1/8/2008
Where's
letter.
the rules?
Rule. My rule is my lord, the Assam Stenographer Service Rules 1995. Lordship, it is in page number 338 of this book.
Where's the educational qualification?
Yes, Lordship will find it in the schedule at page 350.
Three?
350.
Each.
My lord, page 349, sorry. 349. Schedule 1, Part A, Rule 8. One is stenographer grade 3, which is my lord, the issue in question hearing. Number 2, my lord. National Trade Certificate in Stenography English awarded to the trainees from the Industrial Training Institute in Assam by the National Council for Vocational Training after the 1st of August. So these particular qualifications the petitioner does not. On the day when the selections were held, or on the day when the applications were at least submitted, pursuant to the advertisement of 2008. Yeah, of 2008.
What is the method of recruitment?
That rule number 6. It's direct recruitment for the post of grade 3 stenographer. 6(1)(d) my lord, prescribes that it will have to be by a commission or board, as the case may be, shall furnish to the government a list of qualified candidates in order to order the preference in each cadre separately in accordance with the scheme of selection given in schedule 3. So it will have to be forwarded to the government for approval. Now, in the present case, my lord, there is no such approval given.
Certificate. But we don't have that from ITI, which always.
And this committee can only recommend, madam. Not that man directly, they can be appointed.
Will the approval required in the rules?
Madam. But that appears that, madam, that 6(1), Rule 6, sub rule 1, clause D, madam, page 342. D1.
Yes. D?
D, madam.
6(1)(d).
6(1)(d), then Roman 1, madam.
Yes.
So my humble submission is that, my lord, it is apparent that, my lord, this particular appellants, my lord, two appellants, they, on the day when the selections were held or on the day when they submitted the application, they did not have that particular qualification. And my lord, this honorable court by the order passed in the first writ petition, nowhere gave any liberty to the appellants to, my lord, require a qualification. In fact, my lord, there is only an observation giving a liberty to the department or the government to take a call in this regard, whether they should be given an opportunity or not. An opportunity pursuant to that order was given, but that was again interfered by this honorable court in the second writ petition. And in the second speaking order, which is under challenge, which was under challenge before the learned single judge in the third writ petition, this particular, my lord, the authorities finally decided that the selection should be cancelled and a fresh selection should be held. And that particular speaking order has been upheld by the, my lord, learned single judge. That lordship will find already it has been pointed out. Page 163. Para 30. As a result of the above discussion and for the reasons assigned therein, the orders of appointment dated 17/6/2008 are found unsustainable in law. And such appointments being illegal cannot receive judicial imprimatur. Consequently, the assailment made to the order dated 18/8/2016 fails. The interim order so and so recalled and the competition authority shall pass the consequential orders according. So 18/8/2016 was the last speaking order passed. It has been upheld. There is the decision of the government.
Lord, in item number 6, I am private respondent number 5, and item number 7, I am the opinion. My lord, it's a very pathetic story of a lady, my lord, fighting for last 17 years, unmarried lady. She started her, my lord, campaign, I should say campaign, my lord, in 28 years, now she is 45 years. 4 rounds of litigation. She is eligible and selected. But
She's eligible and selected.
eligible and selected. My lord, first I take your lordship. I'll be very brief. Straight to the first round of litigation, the judgment. Page 43. In 2007, there was an advertisement. She took part. Result has not been declared. Now 2008 advertisement. It is regarding 2008 advertisement.
Page?
Page 43, the last page, my lord, of the first round of litigation. Judgment.
Popular petition.
My appeal petition.
You appeal.
My lord.
Okay.
Item 7. Writ appeal number 10 of 23. Challenging the same common judgment and order, my lord, as in item 6. Page 43.
Yes.
The first paragraph, my lord, from 4th line. All the above aspects of the matter, page 43, my lord. All the above aspects of the matter will require consideration of the Commissioner and Secretary to the Government of Assam in the General Administration Department. Accordingly, this writ petition is disposed of directing the said authority to examine the matter in the light of the discussions made above and the materials available on record, and to pass appropriate orders as may be expedient in law. While taking action in terms of this order, it is important, my lord. While taking action in terms of this order, the authority may also consider, not appoint, my lord. Direction was not for appointing the underqualified, my lord, appellants, my lord, in item number 6. authority may also consider whether in the meantime, the two respondents have acquired the required qualification and or whether they should be given opportunity to acquire the same. Let the entire exercise be carried out as expeditiously as possible, preferably within 4 months from today. So, up to the advertisement and also up to the interview, my lord, those two respondents, now appellants in item number 6, they do not have the requisite qualification as per stenographer rule 1995. So, my lord, Supreme Court is also clear, my lord, that Koustuv Kumar Sharma, 3 judges bench, and I'll place the judgments later, my lord. Now, if I come to the qualification aspect first, my lord, that is the, my lord, main issue revolving around that qualification aspect, my lord. They are underqualified and I am qualified. Now kindly turn to the stenographer rules. Section 8, Rule 8, page 343. Page 343, 22 edition. Academic qualification. Their academic qualifications of a candidate for appointment to each cadre shall be as prescribed by the government from time to time. The qualifications and experience prescribed as on the date of commencement of these rules are given in Schedule 1, Part A and B. Now finally turn to Schedule 1. Page 349. So, my lord, this particularly clause 2, Schedule 1, Part A, Rule 8, clause 2. The National Trade Certificate in Stenography English awarded to the trainees from the Industrial Training Institutes in Assam by the National Council for Vocational Trade after the 1st August 1975 and Diploma in Stenography from Government Recognized Polytechnic of the state shall be recognized as the certificate of requisite qualification for the purpose of direct recruitment as stenographer grade 3 English, provided the candidate possesses the requisite academic qualification as prescribed at paragraph 1 above. So, my lord, the Schedule 1 is clear, my lord. The qualification of stenographer grade 3, direct recruitment. They do not possess those certificates, my lord. Okay. Now, the selection process. Schedule 3, page 351, scheme of selection. 351, Schedule 3. Scheme of selection. 1. Unless there is anything separately mentioned in this schedule, stenography means taking dictation and preparing typewritten transcript, copy of the passage dictated. WPM means and so language, Hindi, Assamese, English. Now next page, my lord. The scheme of selection will comprise 2 parts: stenography dictation and composition. And 3, the time allocated, my lord. We can skip 3, now 4, my lord. A candidate shall be considered suitable for being recommended for the appointment if the percentage of mistake in transcribing the test passage dictated does not exceed 7.5 of the total number of words transcribed. 5. The commission board shall allot marks for the transcription of the test passage and for the composition as considered suitable, and shall award marks on the basis of the quality of the transcribed passage as well as performance on composition paper. 6. The commission board shall verify the original certificate, etc. of each candidate before the test. 7. The names of the candidates recommended for appointment shall be arranged on the basis of the aggregate marks obtained by the candidates. In case of, next page, Miller. In case of equality of aggregate marks of 2 or more candidates, the names of such candidates shall be arranged according to the marks obtained in the transcription of the dictation test passage. Now, clause 8, Miller, it is important. The commission board shall prepare a combined merit list of the candidate for appointment as English stenographer and language stenographer in accordance with the procedure laid down under paragraph 7 above. The commission board shall not recommend any candidate for appointment who does not possess the prescribed qualification of speed in stenography. So, my lord, that first test, the speed test, my lord, everyone qualified, my lord, the private respondent to the appellants, my lord, in item 6, and the present appellant in item 7. My lord, thereafter, my lord, they acquired qualification after this judgment, first in 2011. Advertisement was of 2008. Interview was held, selection test was held, my lord, 2008. After 2011, they have acquired the qualification. Now, what Supreme Court says, my lord, particularly a division bench of this honorable court, my lord. An old case, my lord. 4 judges bench. (1976) 2 SCC 128. 1976 Volume 2 Supreme Court Cases 128. Hukum San Shyamlal versus Union of India and others. Particularly paragraph 18. The last page. First 4 lines. Last page, paragraph 18. It is well settled that where a power is required to be exercised by a certain authority in a certain way, it should be exercised in that manner and or not at all, and all other modes of performance are necessarily forbidden. It is all the more necessary to observe this rule where power is of drastic nature and its exercise in a mode other than the one provided will be violative of the fundamental principles of natural justice. Oh, my lord, a division bench judge, Ime, Bobby, and another, my lord. (2021) Volume 3 DLT, page 33. Page 33, 2021, Volume 3 DLP. Ime, Bobby, and another versus Guwahati High Court and another. It is regarding the appointment of system analyst in Itanagar Bench of this honorable court. Now, kindly take up paragraph 17. Division bench judgment. Paragraph 17. May I read? Paragraph 17. 17 to 21, relevant paragraphs. Paragraph 17. In the case of Rakesh Kumar Sharma versus Government NCT of Delhi, reported in 2013, the Apex Court has taken note of the various judgments of the Apex Court, wherein it has been held that the eligibility of a person would have to be decided as on the cut-off date for filing of applications appointed in the advertisement. So it should be in 2008 itself, not 2011 or thereafter. Further, the 3 judges bench in Ashok Kumar Sharma versus Chandra Shekhar reported in 1997 so has observed as follows. It is important. The proposition that where applications are called for prescribing a particular date as the last date for filing the applications, the eligibility of the candidate shall have to be judged with reference to that date, and that date alone is a well-established one. A person who acquires the prescribed qualification subsequent to such prescribed date cannot be considered at all. An advertisement or notification issued or published calling for applications constitutes a representation to the public, and the authority issuing it is bound by such representation. It cannot act contrary to it. One reason behind this proposition is that if it were known to that persons who obtained the qualifications after the prescribed date, but before the date of interview, would be allowed to appear for the interview, other similarly placed persons could also have applied. Thus, because some of the persons had applied notwithstanding that they had not acquired the prescribed qualifications by the prescribed date, they could not have been treated on a preferential basis. Their applications ought to have been rejected at the inception itself. This proposition is indisputable and in fact was not doubted or disputed in the majority judgment. In view of the above, now our division bench Millard judgment Millard, their observations Millard. In view of the above, the stand taken by the council of so-and-so that so-and-so should be allowed to continue in service as he had the required eligibility criteria prior to the written test and selection process having started cannot be allowed, as the same is not permissible in terms of the judgment of 3 judges bench of the Apex Court in Ashok Kumar Sharma Supra. 18. Paragraph 18. In the case of Rakesh Kumar Sharma versus Government, NCT of Delhi, the Apex Court held that there is no obligation on the court to protect an illegal appointment. The extraordinary power of the court should be used only in an appropriate case to advance the cause of justice and not to defeat the rights of others or create arbitrariness. Usurpation of a post by an ineligible candidate in any circumstance is impossible. We are thus not inclined to invoke the equity jurisdiction of this court. It is important. We are thus not inclined to invoke the equity jurisdiction of this court in view of the law laid down in Ashok Kumar Sharma and Rakesh Kumar Sharma. Next paragraph. In view of the above reasons, the prayer made by so-and-so to allow him to continue in the post of system analyst by invoking the equity jurisdiction of this court is rejected. Next paragraph. The next question that arises for consideration is as to whether so-and-so, Ms. Ime Bobby, the appellant, should be appointed to the post of system analyst, as the service of so-and-so had been terminated on the ground that he did not have the eligibility criteria for being considered for the post, and as his appointment was an illegal appointment. The stand taken by the respondents is that as so-and-so had been appointed to the said post on so-and-so date, the select list got extinguished. Thus, the post had to be filled up by way of a fresh selection process to be made in pursuant to a fresh advertisement to be published. In this respect, the respondents have relied upon the judgment of the Apex Court in Rakhi Ray and others versus the High Court of Delhi and others, wherein it has been held that any appointment made beyond the number of vacancies advertised is without jurisdiction, being violative of Article 14 and 16(1) of the Constitution of India. The Apex Court further held that appointment made in excess of the notified vacancies would be nullity, inexecutable and unenforceable in law. The Apex Court thus held that when the notified vacancies stood filled up, the process of selection comes to an end as the select list gets exhausted and the waiting list, etc., cannot be used as a reservoir to fill up vacancies which came into existence after the issuance of the advertisement. The Apex Court thus held that the unexhausted select list waiting list becomes meaningless and cannot be pressed into service anymore. Next subparameter. The observation made by the Apex Court in Rakhi Ray was made in the facts and circumstances of that case, as the appellants had claimed selection on the basis of future vacancies that arose, while the advertisement was for filling up only 20 vacancies. The High Court had directed the respondents to process their selection for the vacancies that had arisen after the advertisement had been issued. It was in the above context that the Apex Court had held that once the notified vacancies were filled up, the selection process came to an end as the select list stood exhausted. It should also be noted that the question of ineligible candidates being appointed to a notified vacancy was never an issue in Rakhire. Paragraph 21. It is important. The facts in the present case is different. The question is whether the select list could be said to have been revived or whether it was extinguished in the first place if the appointment made was an illegal or void appointment, in as much as the person who was selected and appointed could not have been selected in the first instance due to his ineligibility. Though there is no quarrel with the proposition that once appointments are made, the select list gets exhausted, the said proposition may pertain only to an appointment made in respect of an eligible candidate and not an ineligible candidate. It is squarely applicable to the present case. They are ineligible. They have been appointed 15 years back. I am eligible. I am selected. But for last 15 years, 4 rounds of litigation I am in.
You were not selected, isn't it?
There
were only 2 posts.
2 posts.
So you're making a wrong submission.
No, my lord.
You were not selected.
I have been selected, my lord.
How?
My lord, page 40, my lord.
Page 40 of your appeal.
Yes. Second paragraph, in the middle. In the counter affidavit, page 40, my lord.
Yes.
The first round of litigation, my lord, judge. In the counter affidavit filed by respondent 4, it has been stated that pursuant to the advertisement dated 4/4/2007, which was earlier issued, no qualified candidates could be found, and consequently another advertisement was published on 27/2/2008. In the selection conducted pursuant to the said advertisement, the respondent number 5 and 6 were found suitable, and accordingly, by letter dated 2/5/2008, the Deputy Commissioner Dhemaji intimated the Commissioner Secretary GAD about the same. The respondent 4 has also enclosed the minutes of the selection committee, which will go to show that out of total 110 marks, the respondent 5 and 6 secured 58.5 and 51.6 marks. On the other hand, the petitioner secured 35.6, 25.7, 22.2, 26.3, and 30.7 marks. So, my lord,
how are you selected?
My lord, from this para, it is clear, my lord. They have been selected, my lord. There is no cut-off marks, my lord, as per stenographer rules. No cut-off marks, and
How
the
many
select
vacancies were there? There were 2 vacancies.
2 vacancies.
The appellants were met, were appointed, were selected.
They have been selected,
How
but
can you say you have been selected?
my lord, since there is no cut-off marks, and the select list contains my name also, my lord, and they have not, my lord, rebutted that statement that I have not been selected. Their submission is that I have got lesser marks than the ineligible candidates. This paragraph is also clear, my lord, from their counter affidavit. I have got such and such marks along with other candidates, and the other 2 candidates, ineligible candidates, my lord, they got 58.5 and 51.6. But there is no cut-off marks. Not in the advertisement, not in the rules. In the first round of test, that speed test, they have passed. All have passed, my lord. And the second phase, the interview, they have got this 35, 26, 30, etc. marks. So, my lord, if doctrine of severability applies, my lord, if the 2 candidates go, my lord, then, my lord, the other candidates, the select list, the other candidates in the select list should get preference. It is under the doctrine of severability. My lord, I will place the division bench judgment regarding doctrine of severability.
How does it apply here?
They are ineligible. They have been appointed. If the ineligible candidates from the select list are removed, my lord, then, my lord, the other candidates will have to be considered, my lord. The select list does not get extinguished, my lord, as per Hime Bobi judgment. Paragraph 21 is clear.
Yes, okay.
And now this doctrine of severability is also applicable in this matter, my lord. Khagendra Narayan Borua and another versus State of Assam and others. Division bench judgment. 2002, Volume 1, GLT, page 285.
Yes.
Paragraph 24, my lord. Paragraph 24, my lord. Dr. Khagendra Narayan Borua and another man. As regards the power to relax the qualification, the learned single judge has relied on a decision of district collector and chairman so-and-so, 1993 SCC. There is no second opinion of the application of the ratio of the said case in the instant case. We are also tempted to quote the relevant paragraph of the judgment referred by the learned single judge. Under quote. It must further be realized by all concerned that when an advertisement mentions a particular qualification, next page, and an appointment is made in disregard of the same, it is not a matter only between the appointing authority and the appointee concerned. The aggrieved are all those who had similar or even better qualification than the appointee or appointees, but who had not applied for the post because they did not possess the qualifications mentioned in the advertisement. It amounts to a fraud on public to appoint persons with inferior qualifications in such circumstances, unless it is clearly stated that the qualifications are relaxable. No cost should be a party to a perpetuation of the fraudulent practice. We are afraid that the tribunal lost sight of the fact. Next paragraph. It would really amount to a fraud on the public employment if unqualified persons are appointed by giving some relaxation in the prescribed qualification without being legally authorized to do so. In the instant case, had there been any earlier information for relaxation of age and other requisite qualifications, other similarly situated qualified candidates would have also applied and taken interview. Rule of law does not permit such arbitrariness on the part of the executive action. Next paragraph, paragraph 25. Now we come to the crux of the matter. That is, when the selected candidates, namely so-and-so, have been declared to be ineligible, should the select list as a whole is required to be set aside? From the record, it appears that there is no allegation of disqualification, experience, etc. against Dr. Khagendra Narayan Borua, the appellant so-and-so, save and accept the remarks not being head of department, which is only a preferable requirement after primarily holding the post of professor as per advertisement, and also Dr. so-and-so who were placed at first and sixth position in the select list. When the aforesaid two candidates were found to be eligible, was it correct to set aside the entire select list? Is it falsus in anno, falsus in omnibus, meaning thereby false in one thing, false is everything? Answer is definitely no. In the premises of the facts and circumstances of the case, according to our thoughtful consideration, it is permissible to maintain the select list retaining the name of eligible candidates. It is important, my lord. it is permissible to maintain the select list retaining the name of eligible candidates by severing ineligible candidates, and in our view, that will not be contrary to the accepted norms of the selection procedure. Applying the doctrine of severability, the list of valid candidates recommended duly by an expert body of the commission shall have the enforceability minus those candidates found to be ineligible due to their overage or below experience limit prescribed in the advertisement.
How does it help?
That doctrine severability applies, then, my lord, the two appellants, my lord, their names should be severed and the others will remain. And
What
from,
was the select list? Select list was only of the two appellants.
they should produce the select list then, my lord.
No, not required.
There is no, my lord, only two, incorporating the two candidates' name, there is no select list, my lord. The select list contains total 7 names, my lord. That paragraph, my lord, page 40, it is clear, my lord. Otherwise, in that paragraph, my lord, it would have been, my lord, recorded that they are out of select list, they are waitlisted candidate, and so, my lord. But that paragraph in page 40 is clear. They have got such and such marks.
Read 6 lines above that. Or the 4th line, from the 4th line. In the selection conducted.
4th line, my lord, page, my lord,
40,
my lord.
the same paragraph.
My lord, above that paragraph, my lord.
That same paragraph in the counter affidavit, you leave 3 lines.
May I read again, my lord? In the counter affidavit filed by the respondent number 4, it has been stated that pursuant to the advertisement dated so and so, it is earlier advertisement that was redundant, my lord, which was earlier issued, no qualified candidates could be found, and consequently another advertisement was published on 27/2/2008.
After that,
in the selection conducted pursuant to the said advertisement, the respondent number 5 and 6 were found suitable. Accordingly, by letter dated so and so, Deputy Commissioner intimated Commissioner Secretary GAD about the same.
that's it.
They are selected, but regarding that select list, my
So
lord,
that is the select list.
that, my lord, select list, my lord, has not been, my lord, mentioned, my lord, that those 2 words, my lord. They are selected, my lord. And after that, my lord, the next,
What does select list mean?
the select,
Select list means selected candidates.
yes, my lord, they are selected candidates. All these 7 candidates, my lord. That is why, my lord, record would be required, my lord.
What record?
They don't have that record, my lord. At that time also, my lord. That honorable court, my lord, asked for the select list, but they could not produce the select list. Only the minutes of the selection process.
Okay, proceed.
My lord, so, my lord, the next sentence, my lord, it is important, my lord. The first sentence regarding earlier advertisement, second sentence regarding respondent 5, 6 suitable, and letter was issued for their appointment, and the third sentence, you know, it is important. Respondent 4 has also enclosed the minutes of the selection committee, not the select list, my lord, which will go to show. The minutes will go to show that out of total so and so marks, respondent 5 and 6 so and so secured so and so. On the other hand, petitioner secured so and so marks. Only the minutes, my lord. The names have been given, my lord. Total 7. Their marks, my lord. In the rules, my lord, there are no cut-off marks. In the advertisement, there are no cut-off marks. So if first and second goes, my lord, then third, fourth, fifth will come. And this benefit of judgment, it will go in favor of me, my lord. As per several judgments are there, my lord.
That is why you are challenging the second, the judgment in the writ court, which prescribes for, which did not interfere with the advertisement, correct?
My lord.
In item 7.
Item 7.
You are challenging the judgment.
Yes, my
because
lord.
you don't want to go for the advertisement.
In the judgment, common judgment, impugn judgment, there are 2 parts. One, they are ineligible. To that part, I don't have any objection. But the second part, may I come to
Second part says no interference with the advertisement,
and doctrinal severability won't apply.
no interference with the findings of the government, correct?
Yes, my lord.
To
So,
go for scrapping the interview and go for a fresh test.
to get a clear picture, my lord, that page 108, my lord, of my appeal petition. Page
That
108,
we have already read.
but page 108 and 109, my lord, it is particularly regarding the item 7A plan. 108, paragraph 30. May I read, my lord? Since, my lord, particularly 31 onwards, this is regarding my candidature, my selection, my appointment. So it starts from paragraph 30. The first part is reflected in paragraph 30 that they are ineligible, so their petition dismissed. May I read, my lord? That will give a clear picture before your lordship. My lord. Paragraph 30, page 108. As a result of the above discussion and for the reasons assigned therein, the orders of appointment dated so-and-so are found unsustainable in law, and such appointments being illegal cannot receive judicial imprimatur. Consequently, the assailment made to the order dated so-and-so fails. Thus, the writ petition so-and-so is found unmerited. It is accordingly dismissed. The interim order dated so-and-so stand recalled, and the competent authority shall pass the consequential order accordingly. It is regarding their writ petition. Now, the next para 31. Insofar as the contention raised on behalf of the petitioner in the writ petition, WPC number so-and-so, it is my writ petition, my lord, on the doctrine of severability is concerned, it is noticed that the advertisement dated so-and-so had specifically indicated that the appointment against the sanction post was to be made in accordance with the provisions of section 71Z of the AFREM Act 2005. Section so-and-so of the Act is with a non-obstante clause, and it has stated that notwithstanding any other provision contained in any act or rules, the select list prepared for the fresh appointments to vacant sanction posts shall contain names equal to the number of vacant posts notified at the time of calling for applications for filling up the post. The advertisement dated so-and-so, next page, was published for filling up 2 vacant posts of stenographer. The provision of section so-and-so has stipulated that the select list for 2 numbers of posts should contain only the 2 names and not more. While in the selection process, 2 private respondents were found to have got so-and-so marks, the petitioner was found to have scored 26.3 marks. Nothing is available on record. It is important, Miller. Nothing is available on record as to whether the petitioner got the requisite cutoff mark, if there was any or not. The rules say, Miller, there is no Miller cutoff marks. And the advertisement also does not contain any cutoff marks. And the page 40 is also clear, Miller. Miller, the 7 candidates got such and such marks. There is no select list as such, Miller. Nothing is available on record as to whether the petitioner got the requisite cutoff mark, if there was any or not. Be that as it may, the process of recruitment initiated by the advertisement dated so-and-so for filling up 2 numbers of post of stenographer stood culminated after the preparation of select list in terms of section so-and-so and with the orders of appointment dated so-and-so, whereby the 2 private respondents came to be appointed. The selection process stood culminated with the publication of the select list and the consequent appointments of the candidates from the select list. The setting aside of the 2 private respondents will not result in revival of the selection process by relating it back to the stage where it stood vitiated. Miller, this paragraph, Miller, it goes against that doctrine of severability judgment of the division bench. And also, Miller, that
So you agree with that paragraph?
Miller,
Correct.
Miller.
So you agree with that paragraph?
Miller. Next paragraph also, Miller, reflects the same, Miller. The ratio, Miller, is that, Miller, about the doctrine of severability, Miller. If one is ineligible, then he should go. The next one comes to fill up the void. Now, at the age of 45, Miller, that if we come to the aspect of equity jurisdiction, Miller, at the age of 45, my lord, the appellant. Next, my lord, press selection and such type of thing, my lord. So in this case, my lord, the doctrine and severability squarely applicable. Since the first two candidates are ineligible. And Kime Bobby is clear, my lord. With ineligible candidates, appointment of the ineligible candidates that select list do not get exhausted, my lord.
Where's that act, that, what you call that,
FRBM.
FRBM?
Yeah.
Seven one G.
7(1)(g).
H.
Assam Fiscal Responsibility Budget Management Act 2005, 7(1).
H.
Page 298. Page 298. May I read, my lord? Rule is clear, my lord. 2 vacant posts, 2 names. So here
298.
298. Clause G, 1G. May I read? Notwithstanding any other provision contained in any act or rules, the select list prepared for the fresh appointment to vacant sanction posts shall contain names equal to the number of vacant posts notified at the time of calling for applications for filling up the post. The rule is clear. There should be 2 names, but here it will be different, my lord.
How?
My lord, select list has not been, my lord.
This advertisement is in terms of these rules.
Select list has not been published, my lord, containing these 2 names. Only the minute containing 7 names, my lord. And now kindly turn to that paragraph, section 11, my lord.
Of the same rules.
Same act, my lord. The provision of this act shall be in addition to and not in derogation of the provisions of any law for the time being in force. So that stenographer rule is also clear, my lord. My lord, that's cut-off marks. There is no cut-off marks. And the first phase, there is cut-off marks. That speed, my lord, 7.5. If one gets through that speed test, my lord, then his name should be in the select list. But here a little bit different, my lord. No select list has been published. They will be in the better position to, my lord, place before this honor. This is, my lord, very vital to the entire aspect. If there is a select list, my lord, then my right, my lord, won't be there.
The judgment itself indicates everything.
Page 40, only the minutes of the selection containing all the names.
There's a later part.
And
Later part.
there is
Middle part. The middle part of page 40.
middle part. That paragraph is clear, my lord.
Then
2 were selected, they were appointed. But the names of other candidates are also there, my lord. There is no indication of any FRBM Act, any provision, my lord. The first one. And second one, as per Kime Bobby, as per Khagendra and Borua, the doctrine of severability. If 2 goes, then what happens? That system analyst of Itanagar bench of this Honorable High Court. If first goes, the second one comes to fill up the void, applying the doctrine of severability. And recent judgment, 2021.
Okay.
So if doctrine of severability is applicable in this case, then my name should be considered. And for last, my lord, 17 years, I have been fighting with 4 litigations, my lord. So benefit of judgment should go in favor of me, vis-a-vis other selected candidates. And the picture would be much more clear if the government side places the record, my lord, the minutes, my lord, the select list. My contention is that there is no select list. Page 40. And if equity jurisdiction, my lord, we consider, my lord, regarding, since this honorable court is also a equity court, my lord. Then, my lord, 45 years, my lord, and now fresh selection with fresh candidates, my lord. It would be impossible for her, my lord, without any fault on her part. In the first place, they should not have been selected. It is clear, my lord, they are underqualified. And my this submission, my lord, that should be recorded, my lord, that record of selection, including that select list, that should be placed, my lord.
The select list already, the first judgment indicates.
My lord,
there's no point in
the
recording. such
interpretation of
documents.
that paragraph, my lord, of page 40, it goes both ways, my lord.
I don't know.
So, my lord, that since interpretation is it in favor of the petitioner, then there are some apex court judgments also, my lord. Benefit of doubt, my lord. The select list, my lord, where is the select list? Then the second line of argument, if select list exists containing these two names, ineligible candidates, then Ashok Kumar Sharma, 3 judges bench of Supreme Court, should be applicable. Khagendra Narayan Barua, doctrine of severability would be applicable. Otherwise, entire selection process would be, my lord, redundant one.
Yes.
My lord, that is why, my lord, this, since this court is also a court of equity, my lord.
That part we'll consider.
And my information is that, my lord, now there are 3 vacancies, my lord. There are earlier 2 vacancies, now there are 3 vacancies, my lord. So, my lord, that aspect may also be considered, my lord.
I just give a reply, a quick reply. I should give a reply first to the government, what he said. But as your lordship is fresh, my learned friend, I'll give a reply to that. Because my learned friend first started saying that eligible and selected. Well, I am not, it's it's a yes, my lord. Eligibility who is questioning. What we are saying, there's a proposition of law of the apex court is clear. On the date of submission, last date of submission, the candidate has to be eligible as per the advertisement. What we are saying, in the advertisement, you did mention that it should be from ITI on the date of advertisement. Kindly see the advertisement. That is the second advertisement at page 51. Kindly see 51 on the first paragraph. Applications are invited in standard form as published in the Assam Gazette in Part so and so of Citizens of India defined in Article 5 and 8 of the Constitution, filling up 2 posts of stenographer under the amalgamated establishment of Deputy Commissioner Dhemaji, name of post of stenographer, number of 2 posts, 2 educational qualification, number of posts 2, educational qualification must pass SSLC examination or an equivalent examination of recognized university or board with shorthand and typing speed of 80 and 30 words per minute respectively. Preference will be given to computer diploma holder having knowledge of word processing, scale of pay, and plus otherwise admissible. So, my lord will kindly see, advertisement doesn't mention that you have to be from ITI. Fresh certificate from ITI, it doesn't mention. So, as per the advertisement, we are eligible. That is why they scrutinize and we are invited. And if the rules, what they come, government come and later on say that it is not in pursuance to the rules. That's why they have so underqualified. So my learned friend all the time is saying not eligible, not eligible. If in the advertisement, it would have been spelled out that so and so from the ITI, it is a mandatory, then I don't qualify. I am not eligible. That's why the apex court, my law, all the judgment kindly recollect. It's saying it is not the mistake of the by the applicant. It is the government should have been more cautious. They have not mentioned. Yes, it is true. Subsequently, you said that in pursuant to rule, you have to be a degree from ITI. That's a different thing altogether. But the time of advertisement, my lord, it doesn't spell out that it should be from ITI. My certificate, which I have annexed, kindly see at page 48, 48 and 49, 46 and 48. Kindly see that from ITI,
This is
from Progressive Commercial Institute, not from ITI, because they have not mentioned. This is 46. 46. This is what? Progressive Commercial Institute, because they didn't mention that it should from ITI. Next is 48. Whatever qualification they have laid down, I fulfill. This is one. Secondly, my learned friend, the private party has said that as he has been eligible and selected. Now your lordship is repeatedly asking him, where is that selection? Whether you have been selected. My learned friend has shown one paragraph. My lord, I'll take your lordship to my appeal 326, which I can connect. That is paragraph 40. That is 58, page 58. 58, yes. Page 58, my appeal, as to the marks secured by, lordship got it? As to the marks secured by respondent 5 and 6. That means my lord will kindly note down, it is we. It is not the petitioner, we. Vis-a-vis the petitioner, that's my learned friend's client, have been noted above, irrespective of the fact the petitioner possessed the requisite trade certificate and thereby conform to the requirement of Schedule 1 to the rules, but, my lord will kindly say, but the matter of fact, fact of the matter is that in the selection, they could not qualify. That's my lord, that's what it's now kindly see. In much higher than so and so. Now kindly see the marks, 30 marks are waiting. Para 56, page 56. Kindly see page 56, which my learned friend was showing in the counter affidavit. In the counter affidavit, counter 56B, in the counter affidavit filed by respondent number 4, it has been stated that pursuant to the advertisement dated 4/4/2007, which were earlier issued, no qualified candidate could be found, and consequently another advertisement was published on 27/2/2008. In the selection conducted pursuant to the said advertisement, the respondent 5 and 6 were found suitable, and accordingly, by letter dated 2/5/2008, Deputy Commissioner Dhemaji intimated the Commissioner Secretary General Administration. Respondent number 4 has also enclosed the minutes of selection, which goes to show out of total 110 mark, respondent number 5 and 6 secured 58.5, 51.6, that is the appellant. On the other hand, the petitioner scored 30.56, 25.7, 22.2, 26.3 and 30.7. So, my lord, with this mark, with the appellant, which is the present case, they doesn't qualify. That is why I read again, my lord, kindly see para 50, page 58, my lord, what the learned single judge observed. Clearly they have said, learned single judge, my lord. This is what against, my lord, as to the marks secured by respondent 5 and 6, vis-a-vis the petitioner have been noted above, irrespective of the fact, petitioner possesses the requisite trade certificate and thereby conform to the requirement of Schedule 1 to the rules, but the fact of the matter is that in the selection, they could not qualify. What more, my lord? Today, they are saying that whether this finding has been put to challenge by them. This finding has not been put to challenge. Today, my learned friend is arguing that no, there is a select list. They should produce a select list. But this finding, you did not challenge this finding. Second, this is what my learned friend, severity will not come in this particular case. There are two posts. Two posts has been advertised, my lord. Learned single judge finding is there. They have not been selected. They cannot qualify. Man, eligibility, having trade is a different. But in marks, they doesn't qualify. That marks. That's end of the matter. Where is the question of bringing those doctrine, my lord? Not doctrine only is applicable when you qualify. The doctrine is not applicable in this present case. Some few judgment has been cited by my learned friend. That's fact, my lord. We are not denying to that, my lord. Last date of submission, my lord. You should have the necessary qualification. That's there, my lord. How can I deny that there's a judgment by the apex court? What is the case in the present hand? Whether it stipulates in the advertisement, it doesn't stipulate. This is our case. So I think my learned friend's argument doesn't have any leg to stand in this particular case. So far as the stand taken by the government, my lord, saying that that certificate, that order passed by the government 18/11/2016, am I right? 18/11/2016 in pursuance to the order passed by this court. So that is cancelled by the second round of litigation. But my acquiring of that certificate is still holds good today. It has not been cancelled. You did not cancel it. You cancelled subsequently because of the courts cancel that 18/11/2016 letter, whereby I was allowed. And in fact, after allowing it, I completed that training. The certificate is with me. I hold a certificate. You may cancel that order, but as on date, I have that certificate. That certificate has not been cancelled. Now, worst to worst case, by the apex court, what it said, subsequently also, putting in so long years of service, you can send it for training for that course. You could not disturb. You should not disturb, in fact. So I think that particular, the argument which is advanced by my learned friend, Mr. Gogoi, that doesn't hold good. And my learned friend also has taken the same, that we don't, that qualification, eligibility criteria. That again, I don't want, my lord, same stand, I reiterate the stand which I have explained to your lordship. Last day of submission of form, it was not. Neither, my lord, may kindly see, they did not challenge the advertisement. They should have challenged. They did not. They participated. My learned friend participated. They were not selected. I was appointed. Only after that they come to the court. Then they come to the court. Otherwise, you could have challenged the advertisement. You could have said that what advertisement you have made, this is required as per rules. You did not challenge that. Once you became unsuccessful, then you come to the court and say that no, these are violation of the rules. So this is my humble submission before your lordship. No, your lordship will kindly consider, because of my length of service which I have been continuing, my lord, till today.
Yes, but Standing counsel, GAD correspondence 1, 2, and 3.
Yeah.
Deputy Commissioner, Mr. R.K. Voral, Cabinet correspondent 4, and Mr. P.G. Fukan.
Milord, respondent 5, private respondent. And also in Boda appeal and
Hearing complete.
most of them.
May it please your lordship. This matter, the last occasion your lordship heard. And my lord, on my request, your lordship has said that the matter can be taken up for disposal. My lord, I'll state the facts a little bit and then I'll go to the order passed by the learned single judge. Now, my lord, I'll hand over.
That was before different bench.
Oh, yes, yes.
So you may have to re-argue because my brother's.
Well, that day, the argument was not so much, a little bit we argued, but on my request, it was deferred. So therefore, it was not heard in part.
Yes.
So, my lord, I will just give the small list of facts, my lord. The facts is, my lord, jumble of fact, that's why I'll read from this and the page where it is located, that also I'll take your lordships. Your appellant is serving as an assistant professor and head of the Department of Computer Science and Application in Karimganj College as affiliated college under Assam University. He obtained MPhil degree in the year 29/9/2008. These dates are very important, my lord. MPhil degree in the year 29/9/2008 and PhD degree in the year 25/2014. Pursuant to advertisement dated 8/5/2017, which your lordship will find at page 59, in 3 of Pandit Deen Dayal Upadhyay Mahavidyalaya, that is Amjanga, this is a place, my lord, 3 places, Amjanga, Tulungia and Dalgaon. In short, your appellant applied for the post of Assistant Professor Computer Science. Selection committee of 2 institutions awarded marks to the appellant in terms of office memorandum dated 25/6/2012, which is at page 84. Now that OM dated 25/6/2012 demonstrate that a candidate having MPhil degree is entitled to 5 marks and for teaching experience maximum 5 marks, 1 mark for each completed year of service in an affiliated government degree college. Your appellant being UGC qualified teacher from 2008 year of obtaining MPhil degree till the year of, my lord, this line is very important, till the year of interview, that is 2017. Your appellant has completed 9 years of service, which entitle him maximum 5 marks on teaching experience. Now, selection committee of Amjanga awarded 5 marks to the appellant on MPhil and also awarded 5 marks on teaching experience. Your lordship will get it at page 66. Then appellant has been awarded 5 marks on MPhil and 5 marks on teaching experience by selection committee of Tulungia. It is astonishing to find that same subject teachers who awarded 5 marks in MPhil and 5 marks in teaching experience in Amjanga have awarded 0 marks, your lordship can see, 0 marks on MPhil and 2 marks on teaching experience by the selection committee of Dalgaon. Then Government of Assam has recognized qualifying marks on MPhil degree, the candidate who obtained the same before 10/7/2009. The notification also annexed. Now, the main ground of the appellant in the writ petition as well as the writ appeal is that the terms of office memorandum dated 25/6/2012, appellant is entitled to maximum 5 marks under the head teaching experience, that is 1 mark each completed year of service in an affiliated college. Your appellant being UGC qualified teacher from 2008 till the year of interview, that is 2017. Your appellant has completed 9 years of active service, which entitled him maximum 5 marks on teaching experience. Now, my lord, I will take your lordships at page 84. That is the office memorandum. How the marks to be, my lord, evaluated at page 84. This is office memorandum dated 25/6/2012. Your lordship may look at page 85. My lord, down below, distribution of marks. Your lordship may skip this. Now, page 86, my lord. Your Lordship may come to MPhil degree. B, Your Lordship will find research performance. Now, this is the PhD degree. For that, my lord, I did not ask for any marks because I am not entitled to. Because Your Lordship will find that there will be no marks for the PhD degree if it is counted in lieu of NET/SAT. So I did not have those qualifications. Therefore, for PhD, I am not entitled to get any marks. I did not ask. But the finding of the learned single judge, Your Lordship will find experience in PhD. This is a totally wrong connotation. Now, Your Lordship may come down to MPhil degree. The next MPhil degree from UGC recognized and Government of Assam approved university. Marks allotted 5. Now, Your Lordship appreciate that I have got the MPhil degree in the year 2008 and that advertisement came in 2017. In between, my lord, as a UGC qualified teacher, I worked there for 9 years. My lord, I am entitled to get, I will not get 9 marks because the maximum is 5. Therefore, these 5 marks I am entitled. This was my first argument. On this, Your Lordship will find learned single judge did not deal with it. Totally ignored, and if fall back to, my lord, that is the experience in teaching, saying that the year spent in my PhD degree, getting PhD degree and MPhil, the year spent on this studying period, that will not be counted. I am not asking for that at all. It is not required. Because after getting MPhil degree, I have 9 years of experience. So I am entitled to get 5 marks from there. That was ignored totally. Now, Your Lordship, kindly come down to 2 teaching experience. Down below, my lord, in the middle part, Your Lordship will find teaching experience, 1 mark for each completed year of service in an affiliated government degree college, subject to maximum 5 marks. Although I am having 9 years of experience, I will not get 9 marks, is maximum 5 marks I will get. And Your Lordship will find 2 of the institution, that is Tulungia and Amjanga. Rightly, they have allotted 5 marks on MPhil, 5 marks on teaching experience. But then Dalgaon, they did not give that marks. I will take Your Lordships to that. My lord, office memorandum, Your Lordship will find at page 66. Page 66, Your Lordship will find serial number 68. This is the Rajiv Das, she is the appellant. As Your Lordship found it. 66. In the left column, Your Lordship will find serial number. I am in 68, that is Rajiv Das.
Serial number.
Serial number 68.
Yes.
Rajiv Das. Your Lordship may see in the right hand side, MPhil. He has given 5 marks.
Yes.
Then teaching experience, the extreme right hand side, my lord, 5 marks.
Yes, Amjunga.
Amjanga. This is Amjanga, yes. My lord, it's time to rise. Your Lordship will take it to One of them will still remain vacant because one of the
Other institutions, all filled up.
all filled up. And so far Dalgaon is concerned, there is an order of this honorable court to keep a post vacant. Apart from that, one candidate did not join, so it remained vacant. Now, in page 66, another thing I will take Your Lordship to see, but it is no longer required to be gone into. Your Lordship will find in the extreme right, not eligible for non-proficiency in local language. Learned single judge set aside this. So it is not required to gone into. Now, Your Lordship, now see at page 770. 70, Your Lordship will find subject expert Professor T. Bejwarua and Dr. Abhijit Sharma. It is down below.
Subject expert.
subject expert. One is Professor T. Bejborua and one is Dr. Avijit Sharma. My lord, why I am referring, your lordship will see these two subject teachers has given in Dolgao 0 marks in MPhil and 2 marks in teaching experience. What is the reason? It is not known. And this was also challenged, learned single judge did not go into all that. Then your lordship may see at page 72. This is another institution, Tulungia. Your lordship may kindly see name of the candidate Rajiv Das. This is the appellant. In the middle part, your lordship will find in the left-hand column. This institution also given 5 marks in MPhil and 5 marks in teaching experience. They rightly gave these marks. Now, your lordship, kindly see at page 82. This is Dalgaon, my lord. Your lordship may look at serial number 54 in the left-hand side. Rajiv Das MPhil, your lordship will find 0 marks. And then teaching experience 22. The subject expert is Dr. A. Sharma and Professor T. Bejborua. Same subject expert, my lord. This is the height of all, my lord, apathy, negligence, whatnot. Then, my lord, I'll take your lordships, my lord, the alternative argument which we placed, it was not necessary to look at because the experience we have for 9 years as a UGC qualified teacher, because I passed through in MPhil in 2008. Advertisement was in 2017. Now, after passing as a UGC qualified teacher, I have been teaching in the college as a regular assistant professor for long 9 years. Now, as I can get maximum marks of 5, my lord, I am eligible to get that. Now, I will take your lordships to those points which single judge discussed, which is not necessary. My lord, your lordship may come to page 108. This is the DO letter by the Vice Chancellor of the University Grants Commission. The issue regarding counting of the period of active service spent on pursuing PhD was considered by the UGC in its so-and-so. The clarification of University Grants Commission is as follows. The period of active service spent on pursuing research degree for acquiring PhD degree simultaneously without taking any kind of leave may be counted as teaching experience for the purpose of direct recruitment, that is assistant professor, and the promotion to the post of associate professor and above. Now, the UGC Grant Commission is saying a person who is, my lord, studying the research at the same time without taking leave of the college, my lord, if he in teaching assignment, that period is required to be counted. In my case, my lord, I will not argue this is not required at all because I am having sufficient experience, teaching experience as a MPhil teacher. As learned single judge dealt with this, here the notification says I am entitled to that marks also, but in my case, it is not necessary. Then your lordship may see page 127. That is at 127, your lordship will see the UGC notification, point number 3.9.0. Lordship got it. The period of time taken by candidates to acquire MPhil and or PhD degree shall not be considered as teaching research experience to be claimed for appointment to the teaching position. Lord, this is a case where when I'm doing my research study, if I take leave and do my study without any teaching assignment, I'm not entitled to any marks. My lord, even I don't get any marks also, it's not affecting me. Now your lordship may see at page 196. Relevant part your lordship will find at 198, clause 3.11. The time taken by candidates to acquire MPhil and or PhD degree shall not be considered as teaching research experience to be claimed for appointment to the teaching positions. Further, the period of active service spent on pursuing research degree simultaneously with teaching assignment without taking any kind of leave shall be counted as teaching experience for the purpose of direct recruitment promotion. Regular faculty members up to 20%, these are not required. Now, well, these are the points I am not arguing because this is not required also. Since learned single just dealt with that, I have just referred to your lordships. Now I will take your lordships to the impugn judgment, which is at page
169. Delivered 171.
your lordship. Your lordship may come at 171. The order dated 16/3/2023. By filing this writ petition under Article 226 of the Constitution of India, the petitioner has prayed for directing the respondent authorities to award appropriate marks to the petitioner in accordance with OM dated 25/6/2012 in MPhil and teaching experience, and thereafter to appoint the petitioner in the post of Assistant Professor, Information Technology, Computer Science. The petitioner has projected that he is serving as Assistant Professor in the Karimganj College since 1/7/2005, and presently he is the head of Department of Computer Science and Application under self-financing scheme in the said college. The petitioner had acquired PhD degree in computer science from Assam University, Silchar, which was conferred in the 14th convocation held on so-and-so. In course of service on 19/12/2006, the petitioner got himself enrolled in MPhil degree course in Annamalai University under distance education mode after obtaining no objection certificate from his employer college. The petitioner was awarded his Master of Philosophy in Computer Science degree by the said Annamalai University. Your lordship may skip that. The para 4 also your lordship may skip. Then paragraph 5. The points raised by the learned senior counsel for the petition is discussed issue-wise. The issues raised are summarized as follows. Whether the petitioner was awarded lesser marks by not treating time spent for pursuing MPhil and PhD degree as teaching experience. B, whether the petitioner was illegally denied marks despite having MPhil degree. Whether the petitioner was awarded lesser marks by UF, hostile discrimination on account of language. This is no more important because the learned single judge has set at rest. So this C is no more required, my lord. On whether lesser mark was awarded to the petitioner by not treating time spent in pursuing MPhil and PhD degree. The learned senior counsel for the petitioner has submitted that at Dalgaon, the petitioner had been given 8.01 marks less, and at PDUM Tulungia, he was given 1.03 marks less, which is in violation of OM dated so-and-so. It is also submitted that as per the petitioner assessment, he was ideally entitled to 63.94 marks amongst others, because the petitioner was entitled to 5 marks for teaching experience, 5 marks for his MPhil degree, and 5 marks for PhD. My lord, your lordship may appoint this 5 marks for PhD degree. This is not at all correct because I never prayed for 5 marks for PhD degree because I am not entitled to. So therefore, these your lordship kindly note it, and 5 marks for PhD degree. The chart showing marks awarded were as follows. The chart is, your lordship will see, page 174. The lordship has already seen. In Amjanga, my lord, MPhil, they have given 5 marks. In Tulungia, they have given 5 marks. In Dolgaon, they have given 0. Then down below teaching experience, your lordship will find 5 marks in Amjanga, 5 in Tulungia, in Dolgaon 2. My lord, no justification why they have given these marks. To project entitlement of the petitioner to 5 marks for teaching experience, it is submitted that although under OM dated 25/6/2012, it was provided that the period of time taken to acquire MPhil and or PhD degree shall not be considered as teaching research experience to be claimed for appointment to the positions, but by communication dated so-and-so, the Secretary UGC had clarified that the period of active service spent on pursuing research degree, that is for acquiring PhD degree simultaneously without taking any kind of leave, may be counted as teaching experience for the purpose of direct recruitment promotion to the post of associate professor and above. Accordingly, it is submitted that the MPhil degree being research-based, the same principle would apply there also. Now, your lordship kindly see in this part. Now, learned single judge did not, my lord, answer the question posed to the court that, my lord, in MPhil, I am entitled to get 5 marks. And teaching experience, since I am having experience from 2008 to 2017, for long 9 years, I am entitled to marks in teaching, 5 marks in the teaching experience. So this part of the alternative submission which was made, that was focused in this judgment, which is not necessary at all. My lord, I will not argue that I am entitled to get time spent in studying my research course. It is not needed at all. If you don't give me also, I'm not losing anything because I am having sufficient years of experience after getting my MPhil. Now, paragraph 8, my lord. Par contra, the learned standing counsel for the higher education department has countered the communication of the Secretary UGC dated 1/3/2016 by submitting that as per clause 3.9.0 of the University Grants Commission on minimum qualifications for appointment of teachers and other academic staff in universities and colleges and measures for the maintenance of standards in higher education, Regulation 2016, published in the official gazette by UGC notification dated so-and-so, it is provided that the period of time taken by candidates to acquire MPhil and or PhD degree shall not be considered in teaching research experience to be claimed for appointment in teaching positions. In the office memorandum dated 25/6/2012, it has been mentioned in clause 7 thereto that the period of time taken by candidates to acquire MPhil and or PhD degree shall not be considered as teaching research experience to be claimed for appointment to the positions 3.9.0. The learned standing counsel for the higher education department has demonstrated that the reference regarding so-and-so mentioned in clause so-and-so and the OM dated 25/6/2012 is preferable to UGC regulations on minimum qualifications for appointment of teachers and other academic staff in universities and colleges and measures for the maintenance of standards. Now, these are all, my lord, not disputed thing. Then your lordship kindly see paragraph 10. Thus, the point of determination number A is answered by holding that the respondent number 2 had not committed any illegality in refusing to consider marks to the petitioner by treating time spent for pursuing MPhil and or PhD degree as teaching experience, notwithstanding that the petitioner might have actually rendered service to his college during that time. Now, these are, my lord, superfluous thing, my lord. This is not necessary at all. Now, whether the non-acceptability of the MPhil degree of petitioner is illegal and whether lesser marks was awarded to the petitioner on account of lack of proficiency in local language. The point of determination number 2 and 3 are taken up together. The petitioner had initially approached this court by filing. My lord, your lordship may skip all these things, not necessary. Then your lordship may come to page 178, paragraph 14, my lord. Paragraph 14, my lord, it is seen that in his order dated 18/7/2018, the Director of Higher Education has admitted that there are 4 sanctioned posts of assistant professor in computer science in Dalgaon, and that advertisement had been issued for filling up all the 4 posts. Accordingly, while the candidature of the petitioner was rejected, 4 candidates, namely Muhammad So-and-so and Sri Shubhamay Dev, Sri Shubhrata Chetia, Sri Bikram Patir were appointed. However, Sri Shubhamay Dev had expressed his unwillingness to join, and therefore the other 3 candidates were appointed. The Director of Higher Education had again reiterated the observation made in the said authority earlier order dated 24/1/2018 that as such, even if Sri Rajiv Das is given the marks for teaching experience and MPhil degree, then also he cannot be given the post as the college has very less enrollment. The court finds the reiteration of the said observation not only unjustified, but is again blatant attempt to overreach the order dated 4/9/2017 passed by this court in WPC number so-and-so, and order dated 16/3/2018 in WPC number so-and-so. In both the said orders, this court had emphasized that the director shall give a consideration as to whether the marks for having MPhil degree in the distance mode from the Annamalai University and the marks in the heading experience for having pursued PhD degree should be given to the petitioner. In the considered opinion of the court, as the Director of Higher Education Assam had admitted that 4 posts of assistant professor in computer science was advertised and was being otherwise filled up, but for the refusal of one selected candidate to join, it is not open to the Director of Higher Education Assam to change the stand that because of fewer students, the petitioner cannot be appointed. It may be mentioned that the recruitment process was initiated by advertisement dated 8/5/2017, amongst others for selecting candidates for 4 posts of assistant professor in computer science in Dalgaon, issued by the Deputy Commissioner Darang, Mangalday. A mention has been made regarding the communication dated 25/4/2017, issued by the Director of Higher Education Assam. This would lead to a presumption that the Director of Higher Education Assam has approved of the advertisement for 4 posts of assistant professor in computer science, selected and appointed 4 candidates to fill up all the said 4 posts. But when the said authority has found that it would have to consider the claim of the petitioner, the Director of Higher Education Assam has found a convenient escape route by manufacturing a plea that there are less students in the concerned college. Therefore, from the above, the indelible opinion of the court is that both the then directors of higher education had blatantly attempted to overreach the order dated so-and-so, passed in so-and-so, so-and-so, by manufactured plea that there was less enrollment of students in Dalgaon. The said reasoning of the Director of Higher Education in the MPin order dated so-and-so deserves to be and is accordingly rejected. The learned senior counsel for the petitioner has been able to demonstrate that Bengali is one of the state language of Assam. Moreover, it has been demonstrated that as per, this learned single judge has decided in our favor. So, your lordship may not see to that also. Then your lordship may kindly come at page 181, paragraph 18. Has your lordship got that? In the aforesaid context, the Learned Standing Council for the Higher Education had submitted that the advertisement contained such a clause, and therefore the petitioner having participated in the selection process without challenging the advertisement, the petitioner cannot be permitted to challenge the selection process. This is also not required. Your lordship may skip all these things. Then your lordship may come to page 183, paragraph 19. Therefore, unless the respondent authorities demonstrate from any act, rules, notification, etc., that any local language has been prescribed, your lordship may skip this para also. Then para 21, your lordship can look at. From the impugn order dated 18/7/2018, it is evident that the Director of Higher Education Assam had failed to perform duty cast on him to scrupulously act as per the directions contained in the order dated so and so, passed in so and so, order dated so and so. A passive direction was issued by this court by order dated 16/3/2018, passed in so and so, to consider whether the marks for MPhil and experience in, your lordship kindly say experience in PhD. That is also not correct. The experience in teaching. In the office memorandum, your lordship will find the teaching experience, not experience in PhD. So that is also wrong, my lord. An experience in PhD should be added, and accordingly the order of 24/1/2018 by the Director of Elementary Education, Assam, was set aside, and the matter was again remanded back to the said authority to give an appropriate consideration as required by the order dated so and so. However, for the second time, the Director of Secondary Education, Assam, has failed to do so, as was directed by two successive orders passed on so and so, by ignoring that this court had also requested the Chief Secretary to the Government of Assam that the particular officer, namely B.L. Sharma, the then Director of Higher Education, be instructed in a proper manner that orders of this court are to be followed and not to be overreached and adjusted in a different manner, by further observing that if the orders of the court are not acceptable, it is open for the concerned person to file an appeal or a review in a prescribed manner. But an officer of the government cannot change the orders of the court even if the same are not agreeable. With such an observation, it was provided that the compliance of such action taken by the Chief Secretary shall be informed to the registry of this court, who are not informed as to whether the compliance was intimated to the registry. The Learned Standing Council, this is also not required. Then your lordship may see at page 186, paragraph 25. Therefore, as the Director of Higher Education has failed to comply with the order dated 4/9/2017, passed by this court in WPC number 5403 of 2017, an order dated so and so, for which we are inclined to hold that the impugn order number so and so dated 16/3/2018, passed by the Director of Higher Education of Assam, is set aside and quashed. Now here, your lordship, kindly see one thing. The learned single judge said order dated 16/3/2018 is set aside. This is not correct. Because, my lord, the impugn order was 18/7. Rightly, my lord, the learned single judge rightly quoted impugn order number. I will take your lordship to that. Your lordship may kindly see at page 120. Page 120, your lordship will find impugn order number. In the left-hand side, your lordship kindly see DHC CE CC 51/2017, then 39. Now, at order at page 186, impugn order number DHC CE CC 51/2017, 39. Dated, my lord, date was quoted wrongly, possibly stenographical mistake, my lord. It ought to have been 18/7/2018. Because the impugn order was 18/7/2018. That order was set aside, my lord. For the reasons as discussed above, as regards the point of determination number B and C, the court is of the considered opinion that the competent authority in the higher education department should take a call. We refrain from deciding the matter as it involves examining various notifications and office memorandums of the Higher Education Department of the State University Grants Commission, so and so, so and so. Accordingly, we are inclined to remand the matter for fresh consideration by the authorities in the Higher Education Department, as it is for the second consecutive time that the Director of Higher Education, Assam, has not complied with the order of this court. We are inclined to impose a cost of rupees 25,000 on the Higher Education Department, Government of Assam, to be paid to the petitioner as cost of the litigation, which shall be paid to the petitioner within a period of 1 month from the date of receipt of certified copy of this order. The government in the higher education department will have the liberty to recover the said amount from the concerned officer posted as the Director of Higher Education who had passed the impugn order so and so, so and so. As it is seen that now this part of the order they haven't complied yet. As it is seen that the Director of Higher Education Assam has not complied the requirement of the order dated so and so, so and so, so and so, and has ventured on other relevant issues regarding less number of students and lack of proficiency in local language, which were otherwise irrelevant and not required to be gone into in the light of the directions contained in the herein before, refer two orders of the court. Thus, we pass the following order. Now, these are the orders. The matter for a decision before the head of the department, Secretary, Higher Education Department, as to whether the non-granting of marks to the petitioner for MPhil and experience in PhD. My lord, your lordship kindly see, this cannot be experience. This is the teaching experience, not experience in PhD. For selection and appointment as assistant professor in so-and-so is liable to be interfered with. Now, A is, my lord, there is mistake in the sense, if it is sent to the director, my lord, he'll be confused. Because in the office memorandum, there is no such incorporation in the office memorandum that experience in PhD. This is only teaching experience. Now, B, the said authority shall take note of the grievance of the petitioner that pursuant to employment advertisement dated 2/5/2017, so and so, issued by the respondent number 4, 5, and 6, respectively, he had applied for selection and appointment to the post of assistant professor of the in the so and so in Amjanga, in Gwalpara district, Tulungia, in Bongaigaon district, Dalgaon, in Darang district. But he was not given marks for MPhil and teaching experience. It is made again experience in PhD. Was not added and resultantly his candidature was rejected. While examining the matter, it would be open to the said authority to examine whether the MPhil and PhD degree granted to the petitioner would entitle the petitioner any advantage in securing appointment to the post of assistant professor in computer science in the concerned college, without commenting on validity or otherwise of the degree, as the validity of the degree is not under challenge. Now, the learned single judge accepted the MPhil degree and the PhD degree, whatever he has acquired, that is legal, and since it is not in challenge. The said authority shall take note of the fact that in this order we have already adjudicated and decided that the petitioner would not be entitled to marks for time taken by the petitioner to acquire his MPhil and PhD degree by considering it as teaching research experience to be claimed for appointment to the teaching positions. The head of the department, higher education department, shall pass a speaking order within a period of 30 days from the date of the service of the certified copy of this order on the said authority through his office. Needless to mention that whatever order is passed shall be communicated to the petitioner in his email address to be provided by the petitioner. In the event the authority is of the view that the selection and appointment of the petitioner is entitled to be approved, the said authority shall pass an appropriate order for approval and appointment of the petitioner, if necessary, by creating a supernumerary post with concurrence with other departments like finance, etc. Accordingly, the petitioner shall produce now your lordship kindly see. Now, whether it is required to be sent back to the higher, Director Higher Education, it is not necessary at all. My lord, I will take your lordship to the office memorandum dated 25/6/2012 at page 86. That will make the entire thing very clear. These are all, my lord, unnecessary exercise was conducted. My lord, your lordship again see MPhil degree from UGC recognized and Government of Assam approved university, 5 marks. So on that count, I have been allotted 5 marks by other 2 institutions. But in the Dalgaon, they did not give any marks. And the teaching experience, your lordship kindly see, 5 marks. Now, your lordship will not find in this office memorandum experience in PhD. It is not there. Now, teaching experience, it is said, 1 mark for each completed year of service in an affiliated college. Now, after I got the MPhil degree in the year 2008, up to 2017, I have 9 years of experience, admittedly, my lord. I am entitled to get 5 marks. The two of the institution has given 5 marks. So whether I have spent time in acquiring my PhD degree or MPhil, these are all immaterial, my lord. If no marks is given there, it is not affecting my case. So it is not necessary to send back to them to, my lord, to scrutinize all this. There is no point of adjudication at all. So this is a very small area where your lordship is required to see. Then, my lord, again, I will take your lordship my this written note. In page, your lordship may skip page 1. Page 2, your lordship, my written note, your lordship kindly see. Main ground of the appellant in the writ petition as well as the writ appeal is that in terms of office memorandum dated 25/6/2012, appellant is entitled to maximum 5 marks under the head teaching experience. There is 1 mark for each completed year of service in an affiliated college. Your appellant being UGC qualified teacher from 2008 till the year of interview, that is 2017, your appellant has completed 9 years of active service, which entitle him maximum 5 marks on teaching experience. London single judge did not deal this aspect, vital aspect of the matter, and London is not considering this factual as well as the legal issue. London single judge also did not consider the fact the same subject expert, namely Professor Bejbarua and Dr. A. Sharma, awarded 5 marks on MPhil and 5 marks on teaching experience in Amjanga to the appellant, whereas they have awarded 0 marks on MPhil and 2 marks on teaching experience to the appellant at Dalgaon. Only issue London single judge decided in terms of OM dated 25/6/2001, clause 7 thereto, that the period of time taken by candidates to acquire MPhil and or PhD degree shall not be considered as teaching research experience to be claimed for appointment to the position, that is clause 3.9.0. The finding of the learned single judge at paragraph 10 of the judgment stating that respondent number 2 had not committed any illegality in refusing to consider marks to the appellant by treating time spent for pursuing MPhil and or PhD degree as teaching experience, notwithstanding that the petitioner might have actually rendered service to his college during that time. Entire consideration of the learned single judge was not in consonant with the fact situation of the case. When appellant obtained MPhil degree in the year 2008 and has become UGC qualified teacher from 2008 until the date of advertisement, that is 2017, he had teaching experience of 9 years. Therefore, there is no question of reckoning the period of time spent by teacher during research study. That is absolutely not necessary to be added. In paragraph 5A of the judgment, counsel of the writ petitioner argued the petitioner was given lesser marks in teaching experience and he had 9 years of teaching experience as UGC qualified teacher, and alternatively he is also entitled to reckon the period of active service. London single judge did not give any finding on the first argument advanced by the counsel of the appellant. In paragraph 28 of the judgment, London single judge sent the matter before Secretary Higher Education Department as to whether the non-granting of marks to the petitioner for MPhil and experience in PhD for selection and appointment as assistant professor is liable to be interfered with. The case of the appellant is that he is entitled to 5 marks on MPhil and 5 marks on teaching experience. There is no provision in the office memorandum dated 25/6/2012 like experience on PhD as held in paragraph 28A. Likewise, in paragraph 28B, appellant never paid for any mark like experience in PhD. In fact, appellant never paid for any mark under the head PhD. In paragraph 28D, learned single judge failed to decide teaching experience of the appellant for 9 years after he became UGC qualified teacher in the year 2008 till the date of advertisement. It is not necessary to decide whether appellant is entitled to marks for time taken by the appellant to acquire his MPhil and PhD degree by considering it as teaching research experience. It is pertinent to mention That single judge in paragraph 14 of the judgment held in Dolgaon, one of the posts remain vacant. And this honorable court also directed to keep one post vacant for the post of assistant professor. Further, in paragraph 28 of the judgment, this honorable court also directed that if the appointment of the petitioner is to be approved, the authority shall pass an appropriate order for approval and appointment of the appellant, if necessary, by creating a supernumerary post. From the foregoing, it is absolutely clear that the appellant is eligible to get 5 marks under the head MPhil and 5 marks under the head teaching experience. And since one of the post of assistant professor computer science is vacant in Pandit Deendayal Upadhyay Dolgaon, the respondent may be directed to appoint your appellant as assistant professor computer science within a given time frame. Now, this is all about the case. Now, my lord, now my learned friend may cite a decision before your lordships. Let me clarify that also. They will cite a, my lord, last occasion I have handed over the decision whether your lordship is having that. Srimati Asha Rani Brahma. My lord, I'm supplying the fresh 2 copies. My lord. This is the decision, my lord, by a division bench. Your lordship will find in this particular case, my lord, which I have given now, this Asha Rani, he was, my lord, junior research fellowship. There is a scheme, my lord, by the UGC. Under that scheme, my lord, if the student can apply, and they'll get a stipend monthly. Now, they are not a regular assistant professor. Now, in that particular case, what happened? The student claimed 2 marks in a particular given year. But the court ultimately found the junior research fellowship scheme, whenever he is getting some admission to the college, if he, my lord, make a research study along with service, since he cannot do works more than 10 hours in a week, he is not entitled to get any marks in teaching experience. In case, my lord, as a regular teacher, like the appellant here, he completes 40 hours of service in a week. In that case, the teaching experience can be added. Now, they may say this is a covered case. Here also, you cannot, my lord. These, my lord, I will show you, lordship, that this is helping our case. The court has said, if you work for 40 years as a regular teacher in a week, this decision is helping us. Now, I'll take your lordship to those paragraphs, my lord. Your lordship may come to paragraph 18, my lord. I'll just read few of the paragraphs, so will make the thing very clear. Mr. Nair also submitted that even in the OM dated 14/8/2015, issued with the government of Assam, there is a clear reference to the UGC guidelines. He referred to condition number so and so. Teaching experience shall carry 2 marks for 1 year of experience of teaching and undergraduates in a state government recognized college, subject to a maximum of 10 marks. This will be related to actual total hours of teaching imparted by the candidate in the particular year with the standard teaching hours of a regular assistant professor as per UGC guidelines. Further, teaching experience shall be counted only for those candidates and to such extent only who have taught the concerned subject after acquiring the eligibility conditions. By referring to the aforesaid condition number 3, Mr. Nair submitted that for counting the teaching experience, it was essential that the candidate concerned must have imparted actual total hours of teaching in the particular year with the standard of teaching hours of a regular assistant professor as per UGC guidelines. He submitted that to qualify the requirements of standard of teaching hours, the person concerned must impart teaching for 40 hours. Let's kindly see this. 40 hours a week as provided by clause 15.1 of the UGC regulations. Mr. Nair referred to the University Grants Commission minimum qualification for appointment of teachers and other academic staff in universities and colleges and other measures for the maintenance of standards in higher education, Regulation 2010, and more particularly the clause 3.9.0, therefore which stipulates that the period of time taken by the candidates to acquire so and so, so and so. Now, Mr. Nair further submitted that the REIT appellant got inducted into the Junior Research Fellowship Scheme being offered by the UGC in the year 2013, and that it does not lie in her mouth to say that the UGC guidelines are not applicable to the state. Referred to the University Grants Commission Junior Research Fellowship in Science, Humanities and Social Science, and more particularly the clause 9 thereof, which provides that the fellow with the consent of the guide, head of the department may assist the university institution in its academic work, provided such work is not likely to hinder the research program on hand. The total, your lordship kindly see this, the total amount of time spent on such activities should not exceed 10 hours a week. Then your lordship page para 23. Mr. Nair further submitted that as the guidelines for JRF prescribe the candidate pursuing a fellowship to spare more than 10 hours a week for activities beyond research, the appellant herein could not have taught for the period of 40 hours mandatorily required under clause 15.1 of the UGC guidelines dated 8/28/6/2010 to count as teaching experience in the process for selection to the post in question. He thus implored the court to affirm the judgment of the learned single judge and to dismiss the appeal. Then your lordship may see para 28. Under clause 9 of the UGC JRF guidelines, the fellow can undertake activities other than the research program only with the consent of the guide, head of the department. No such consent accorded by the head of the department prior to the selection process in question was placed on record by the REIT appellant. Even if the said aspect is ignored for the sake of arguments, in order to claim benefit of 2 marks by virtue of teaching experience, the appellant would have to establish that she taught for minimum period of 40 hours per week in terms of clause 15.1 of the UGC guidelines. However, clause number 9 of the UGC JRF research guidelines clearly prohibits a research fellow from undertaking activities other than the research for more than 10 hours a week. Now, this itself, my lord, abundantly make the thing clear that a person is not entitled to get in this, my lord, Asharani's case. He was a, my lord, junior research fellowship scheme. He got the, my lord, he was working as a research worker and he was doing work 10 hours in a week. Therefore, this honorable court said, this is not a real teaching experience because teaching experience cannot be a fiction. We cannot make an inference. There has to be a real and active teaching experience. Now, 10 years in a week, if you cannot do, my lord, you cannot get any marks as a teaching experience. However, if you do, my lord, teaching job for 40 hours in a week as a regular assistant teacher, you will get that marks. So it covers our case, not their case. So these cases not covering this case, it is covering in the sense in a positive manner, it is helping us. In that sense, my lord, I have referred the judgment because my learned friend will say all these things. Now, there is another judgment of the apex court. If there is slight difference on factual aspect, my lord, your lordship will see every case on the fact situation of a case, and accordingly your lordship will decide. My lord, I will just take it's a big judgment, paragraph 63, I'll just read out, and then I will hand it over to your lordship. My lord, just 2 lines, my lord. It would thus be seen that one additional or different fact can make a world of difference between conclusion in 2 cases, even when the same principles are applied in each case to similar facts. So in this case, what happened, my lord? The fact is totally different fact. the facts in this writ appeal, this Asher and his case, he was a junior fellowship scheme under that he was working for 10 hours in a week. But in our case, 40 hours in a week as a regular assistant teacher. So therefore, there is a world of difference between, and the Lordship may see paragraph 64. My lord, I'll let my learned friend say, then I will reply. So therefore, is nothing to be sent back. It is not a case of remand. It's a very simple matter. I have entitled to get marks on teaching experience as well as MPhil.
Para 62, is it?
64, my lord. That's all.
May please, your lordship. Before going to the merits and law point of the case, lordship, first my lord may kindly come to grounds, lordship, page 18, lordship. Page 18. Lordship may directly come to lordship page 19, lordship. Page 19 and page 20. Page 90 is a ground in relate to the lordship's time taken at the time of acquiring the MPhil and PhD degree, lordship, and for also lordship similar ground. Lordship, if my senior size clarified whether he is lordship that true ground he is insist before this court. If he is not argue on the basis of true grounds, then my argument will be limited. If he still insists that true grounds, then I will advance my argument on the basis of that ground also. So first, my senior size clarified whether he is
placing on that, my lord. My first ground has not been answered by the single judge. My lord, I am on that only. This is not required, my lord. If this point is not taken into account, also is not harming.
Then lordship, the judgment we have placed and which was relied by my seniors are also not applicable in this case. As because he abandoned the true ground. If he abandoned the true grounds, lordship, whether this appeal is lordship on the basis of the right grounds or not. As because honorable single judge did not decide the issue, lord. He has remanded back the matter to the concerned higher authority to examine the issue, lordship, as because the expert opinion is necessary. In respect of other grounds, lordship, regarding teaching experience part and whether MPhil is given or not. That issue was not decided by honorable, it is remanded back to the authority to decide it. As because petitioners abandoned the PhD time spent in the PhD and MPhil degree, I will not advance my argument. Then lordship, the particular judgment which was placed also not relevant in this case. So lordship, we will just lordship, the four corners will be ground number 1, lordship. Only teaching experience part. That was also lordship remanded back to the authority, lord. So lordship may kindly come to the honorable single judge order, lordship. You want to do assessment? My lord may kindly come to page 170. So lordship decision will be lordship limited scope, only limited lordship area. That is whether teaching experience period can be given or not. Or lordship, that part also lordship considered by the authority. As because the whole matter is remanded back to the authority. Regarding its required expert opinion. That was also observed by the honorable single judge. In my opinion, lordship, that instead of deciding this petition, lordship, already single judge has neither decided in his nor decided against the petitioner, lordship. Single judge observation is that authority has to decide the issue and he is entitled to give the appointment in a period of 3 months, lordship. It is not against him, lordship. So basically his ground is first the filing the appeal is on the basis of lordship, the time spent in the PhD and MPhil was not given. That ground, if that issue as their lordship, then appeal will be their lordship. In other grounds, lordship, it will be open to the authority lordship. So lordship, the Honorable Single Justice lordship form a moot question to decide. That is lordship page 172.
Each one?
172 lordship. Paragraph 5 lordship. The issue raised are summarized as follows lordship. Whether the petitioners awarded lesser marks by not treating the span of pursuing MPhil and PhD degree as teaching experience lordship. That part gone lordship. As because petitioner not placed that particular argument. As because it was decided against the petitioner, Honorable Single Justice held that the time spent during the period in the acquiring MPhil and PhD shall not or cannot be treated as a part of teaching experience. As per the UGC regulation 2016 lordship. That part was already decided by the Honorable Single Justice, and my seniors are also not facing it lordship. So that part is gone lordship. Now lordship, whether petitioners was illegally denied the marks despite having PhD degree lordship. And lordship, whether the petitioner awarded lesser marks by way of hostile discrimination on on language, that part also decided by the Honorable Court in favor of the petitioner Single Justice. Now in respect of B lordship, whether the petitioner was illegally denied the marks despite having the MPhil degree. What is the findings of the Honorable Single Justice? So my lord may kindly come to lordship, page 186 lordship. Before that lordship, page 186, paragraph 26 lordship. For the reasons as discussed above, as regards the point of determination number B, in respect of lordship awarding the MPhil marks, the court is of the considered opinion that the competent authority of the higher education department should take a call. We refrain from deciding the matter as it involves examining various notifications and OMs of the higher education department of the state, University Grants Commission, Indira Gandhi National Open University, and Distance Education Council. Therefore, such an examination is left to the higher education department. It's a required expert opinion. So, Honorable Court send it back to the Department of Higher Education lordship to examine the issue, and he is entitled to give that marks lordship. Honorable Court nowhere denied, nowhere decided the issue against the petitioner lordship. In my humble submission, the writ appeal is not maintainable at this stage. After withdrawing the lordship, point number 3 and 4. As because it is left open, the authority till today did not take any, till today no decision was taken by the authority lordship. If the authority taken the decision against the petitioner, then the petitioner can approach the Honorable Court by way of petition order. Otherwise, it is kept open. It is neither in his favor, neither against his lordship petitioner's favor. It is not against the petitioner's lordship. So, in my humble submission, lordship, on the basis of the order passed by the Honorable Single Justice, this writ petition is not maintainable at this stage after doing the ground number 3 and 4. Other parties already left to the authority. If lordship that Honorable Single Justice order is lordship alive, then the authority is yet to take a decision, then lordship may not interfere the Honorable Single Justice order. This is my humble submission. Otherwise, lordship, if the legal point, law point, I can also place the judgment argument on the basis of the law point, whether he is entitled for marks in the PhD or not. As per the law laid down by the Honorable Apex Court in Professor Yaspal case and subsequently the Commercial Institute of Technology cases, he is not entitled the marks for the MPhil marks. Not entitled the marks for obtaining the MPhil degree. As because the particular MPhil degree obtained by the petitioner is for a distance mode, which is not permissible. Even the state from where the petitioner obtained the MPhil degree, it was barred since the year 2007. Their state notification is there. I will place the notification also, lordship. There cannot be any distance of PhD and MPhil degree cannot offer to distance mode. Even in 2005 itself, Professor Yaspal case, Honorable Apex Court says that there is a distinction between the conventional institutions and distance mode and open university.
My lord,
So-
I would like to interfere at this stage.
Sam,
Your lordship, no, because you should not confuse the court. Lordship, kindly see page 188. There should be limit of, my lord.
I am not interfering,
Everyone,
lordship. Let me finish, lordship, after he can reply also.
my lord, he is,
He can, I am not
whatever
confusing
he
the
is
honorable
saying,
court. I am
whatever
not confusing
it
the
should
honorable
be-
court, lordship.
you should be in limit, because you are not placing the facts. Your lordship, kindly see page 188.
Lordship, if the true facts is before the honorable court, lordship.
True
then
facts
su-
I am
then
showing.
such thing
Then
is
you
happened,
say,
lordship.
your lordship,
Such
kindly
thing
see
is
few
happened,
lines. Page 180, he should not argue that.
I am
It
never
is
argue any point.
profession.
I
He
am
should not do
never,
that.
I am never
That is his
argue,
habit.
I am never argue any point beyond the record.
We have
lordship.
seen you, na?
Beyond the record.
Page
lordship.
188.
Beyond the record.
Your lordship, kindly see page 180. This is a habit, my lord. Always he used to confuse the court. Page 188.
Lordship, this kind of submission is not,
I
lordship,
will say
not
100
acceptable
times.
from
I
a
will say
learned
100
senior
times.
counsel. Why he said that I am always submitting, always confusing the court, lordship.
The word
I am appearing
civility,
before the honorable
the
court.
word civility is not in his dictionary.
No,
my lord.
lordship.
Whenever
No,
I
no,
argue with
lordship.
him,
It is
he always
not
begins like
acceptable.
this.
It is not acceptable, lordship.
He should come up from a
It is not
civilized,
acceptable. lordship.
civilized background is needed.
It is not acceptable. I am not interfering.
Your
lordship.
lordship, kindly see page 188. Why I am saying
Why
the
he is
civility is not in his
Let me-
dictionary, your lordship find right now. In page 188, while examining the matter, it would be open to the said authority to examine whether the MPhil and PhD degree granted to the petitioner would entitle the petitioner any advantage in securing appointment to the post of assistant professor in computer science in the concerned college without commenting on validity or otherwise of the degree, as the validity of the degree is not under challenge. Now, we did not challenge this, we didn't file any appeal, and we are saying all these things before the court. My lord, we have a responsibility. Any statement we make before the court, your lordship will go by it. And if it happens to be not correct submission, and your lordship will pass judgment, factually that will not be correct. It is our all responsibility, my lord, to the correct facts. And what the court is saying, it is not in challenge. So therefore, how he makes such submission before the court? Do you take such responsibility?
Okay.
And that's the reason I say civility is not in his dictionary. And he has forgotten all those things.
My submission is that, lordship, the marks for distance mode, lordship, is not, I am not saying that his degree is invalid, lordship. I never said that. In my submission also, not a single point I am saying that his degree is invalid, lordship. I am only saying that, lordship, the degree acquired by the distance mode is, lordship, we are not accepting, lordship. The marks, the degree which is obtained through distance mode, the marks he is not entitled. This is my submission before the honorable court. Time and again, lordship. I will repeat this 100 times, lordship. I am never saying that his degree is invalid.
Any more? Any more submission?
Yes, I have the submission, lordship.
Yes. proceed.
If lordship 3 and 4 is abandoned, I am not submission in that point. Otherwise, I am saying that, lordship, the honorable single judge never decide the issue against the petitioner. It is open for the authority, lordship. Regarding distance mode, lordship, why we are not accepting it, lordship? We are not saying that it is an invalid degree, lordship. Because, lordship, the University Grants Commission, as well as, lordship, the law laid down by the Honorable Apex Court, says that the degree cannot be offered to distance mode beyond the territorial jurisdiction of the particular institute. If the degree is offered beyond the territorial jurisdiction of particular institute, lordship, we are not accepting that particular, we are awarding for marks, lordship. This is my submission. I am not saying that his degree is invalid, lordship. It's a wrong submission before the Honorable Court by a learned senior judge, lordship. Senior counsel, lordship. Now, lordship.
Is it by the same selection committee?
Yes, my lord. Same selection.
Of these 3 districts?
Yes, yes. Same selection committee.
Amjunga, Dulangya?
Longia and Dalgaon.
Dalgaon. But in Amjunga and Dulungia, you are given five
Yes, yes.
five
Full,
marks
full,
each,
full marks.
except in
Except in Dalgaon.
Dalgaon.
And say subject expert. And in the single judge said MPhil is valid. Then why I will not get marks? Is the submission is coming from him?
Same selection committee.
Same selection committee, they may be given the marks, lordship. But it should be proper way, lordship. There is no concept of negative equality, lordship.
What happens in Amjunga and Dulungia?
Already appointment was done, lordship.
But then he was given 5 marks each.
He is given the 5 marks, but he is lordship, whether he is get the service or not lordship. That
No,
is the
that's a
lordship.
different thing.
Lordship,
What I'm saying on the propriety of the
lordship,
selection committee
lordship.
in teaching
Lordship,
experience and
rightly, wrongly, he may be given the 5 marks. I have no issue, lordship. That particular institute where he has not given the 5 marks, lordship. Why he is not given the 5 marks? He is not given the 5 marks as because the committee realized that he is from the distance mode, lordship.
What about the other two districts?
Other two, lordship, today I am not arguing because other two is not an issue before here, lordship. For determination, as because he is insisting that particular institute where he was not given the marks, lordship. Where he was not given the marks. That was also open to the authority. That was also not decided by the Honorable Single Justice. And regarding the lordship, MPhil lordship, I am not saying that his degree is invalid, lordship. The way of obtaining that degree is not proper. Oh. Indeed. I am never misleading the Honorable Court, lordship. 18 years, not a single point, I never misleading Honorable Court, lordship. This is the notification issued by particular state, lordship, where he has obtained the PhD degree, MPhil degree, lordship. That particular state barred it, lordship. This is regarding MPhil, lordship. Now that part I will come, lordship. That part I will come, lordship. That part I will come for teaching experience part, lordship. Judgment to different session. Similar judgment to you. Similar judgment to you.
This with regard to a particular state, isn't it?
That is the state where he belongs to obtain the PhD, MPhil degree to distance, lordship. Otherwise also, lordship, it is barred by the Honorable Appeals Court judgment, lord. Professor Yespal judgment and Command I will raise that judgment, lordship. That is why I will settle it.
Only question, is it
Yes.
open, this point is open to argue, my lord? After
Lordship, this is
page
my submission. Lordship
188.
considered he will take time to, lordship, revert me, lordship. Why interference, lordship?
Yes,
I never interfere anybody,
Proceed,
lordship.
proceed.
Say it gently,
Any-
have some civility with you.
Let him finish, lordship. I will argue.
No, no, all the time, my lord, whenever I argued, when he is the opponent, every time he behaves that way. He has no respect for the age. My lord, it's very unfortunate,
Yes,
my lord.
go, proceed.
Am I interfering him, lordship? I never interfere. Anybody, lordship.
Whatever it is.
Anybody, lordship.
Proceed.
So, lordship may kindly come to the judgment, lordship. There Asani Brahma, lordship.
Which one? Ashwani.
Yes, my
dear.
Asharani.
Asa. Kumansal to this. Kumansal to this mo diya sa. Dekon mo de. Dekon mo de. Dekon mo. Dekon mo.
Yes.
Lordship. This is regarding, lordship, distance mode, lordship. Head note, lordship, page 30, one page, lordship, see. it's clearly stated that a statutory cannot operate beyond its territorial limits, Lordship.
Where is that?
Lordship, C, Lordship, C.
Hmm.
Then Lordship, paragraph 18 and 19, Lordship. 18, 19, 20, 21, Lordship. And 23 also, Lordship. Even that particular Lordship, study centralized Lordship, within the territorial jurisdiction of the state of Uttarakhand, Lordship. That was also not accepted by the Honorable Court as because that particular institute territorial jurisdiction is only the 4 districts of that Lordship, Uttarakhand, Lordship. Beyond the 4 district Lordship, the Honorable Supreme Court says that Lordship, we cannot offer a degree beyond your territorial limit, Lordship. You can operate your Lordship functions within the territorial limit of only 4 districts. Beyond the 4 districts also, Lordship. Here, Lordship, the particular university was in the state of Lordship, Tamil Nadu. Degree was those distance more in Assam, Lordship. Even Honorable Apex Court did not consider the degree which was offered within the state of Uttarakhand. This is the judgment, Lordship. Professor, Professor Yaspas also lost a similar line. I am not Lordship, not explain everything, Lordship. Paragraph 32 onwards, Lordship. Professor Yaspas, Lordship. This is in respect of Lordship, the distance mode, Lordship. Professor Yaspal also paragraph 35 onwards, Lordship. Lordship may, I will not read it, Lordship. Now, Lordship, teaching expense part, Lordship.
Yes.
Teaching expense part. For the teaching expense part, my Lord may again take the judgment of Lordship, Asarani Bohma, Lordship.
Yes.
So, Lordship may directly come to paragraph 18, Lordship. My senior Sahib says that this paragraph 18 helped me. So, Lordship, the contents of the paragraph 18, Lordship. Thus, I am quoted point, Lordship. 3. Teaching experience shall carry, paragraph 18, Lordship, middle part, Lordship.
Yes.
Teaching experience shall carry 2 marks for 1 year of experience of teaching, upgrade, undergraduate in a state of recognized college, subject to maximum of 10 marks. This will be related to actual total hours of teaching imparting by a candidate in a particular year of the standard of teaching hours of a regular assistant professor. My Lord may kindly mark it as per UGC guidelines. He should be a regular assistant professor as per UGC's guidelines. Whether petitioner is a regular assistant professor, he is a temporary and contextual employee. He is not a regular assistant professor also. The word is regular assistant professor. Now, Lordship, as per UGC guidelines, whether he fulfill the required qualification to be a professor, assistant professor or not, he should be, Lordship, either PhD or NET and SLAT person. For that particular period, when he was appointed as a, say, for the Lordship argument, I say that Lordship is a regular assistant professor. Also, he is a contextual employee, Lordship. Then also, Lordship, he should fulfill the UGC's required qualification for the post of professor. Then his service period, which was he served, will be counted as a teaching experience also. His teaching experience marks will be counted from the date of acquiring the PhD degree, from the date of acquiring lordship, Nathan Slate lordship. Since 2009 to obtaining the PhD degree is neither net, neither slate, so that part cannot be counted. And it's very specific lordship. Even P. Susila's case also says that Honorable Supreme Court lordship, MPhil is not a degree, essential or not a qualifications for assistant professor lordship. He should be MPhil or he should be PhD or net slate lordship.
You are sitting only today, no? You are sitting only today, no? Next week you are not here. Mr. Tata. And Gogoi.
Lordship.
I think we are sitting only today.
Well,
So we'll take this some other day. Better we take up some other.
Yes, Lordship, I apologize, Lordship, if anything is done wrong.
my
from my
learned
part,
friends has said he will not mislead. Again, my lord, he is a regular assistant professor. Now he is saying contractual. My lord, but these are the things, my lord.
Regular assistant professor lordship for appointment of assistant professor lordship.
I am really tired of hearing all this.
Assisted by K. Upamanya Learned Council.
Regular assistant professor.
Also had K. Gogoi, then Standing Council,
Higher education.
Higher Education, and Mr. H. Amwal, and Standing Council UGC. Stop. List the matter again on. Shall we take up next week?
All right.
No, that is the difficulty I'm facing.
The bench is not permanent.
The page is not permanent. One permanent bench was there, someone suddenly he took it. When shall we fix it?
My lord, as convenient to your lordship.
What?
Fourth of December, mein.
Yeah.
Obliged, mein.
Item 27.
Have you inserted the page?
My lord, 67, my lord, I have inserted.
Have you inserted page 67?
Yes, yes. The last occasion, my lord, that page number was missing, my lord. So that was inserted, my lord.
Okay. Yeah, who appears on the other side? You are appearing for?
Respondent number 5, my lord.
Aviator.
Aviator. And the state fishery? Yeah.
Nick Council, I'm for a district.
District. Deputy Commissioner. Yes, proceed.
My lord, last annexure, my lord, annexure D, my lord, we have come before your lordship, my lord. The learned single judge, my lord, recall the status quo order passed earlier, that is on 2/8/2023. So against that order, we are before your lordship. My lord, the annexure, the page 91, my lord. Originally, my lord, fishery was settled with the Appellant Society for a period of 7 years, with effect from my lord 21st of May 2013, that is up to 21st of May 2020. Thereafter, my lord, due to some unavoidable circumstances stated in the order, my lord, that was extended for a period of 3 years, my lord. That is with effect from 21st of May 2020 to 21st of May 2023. My lord, during this extended period, my lord, the most part of the fishery was covered by river and the Brahmaputra, and thereafter, my lord, upon representations, the government, my lord, made an inquiry to the director of fishery, and thereafter, my lord, directed the deputy commissioner to allow the appellant society for removal of sand by employing JCB. That is, my lord, thereafter, my lord, the district administration, my lord, issued NOC after 2 years. That is on 15/3/2023. Government issued order on 10/3/2021. But the district administration issued NOC on 15/3/2023, page 91. Annex RD, this is the last page. Peru's government letter so and so dated 10/3/2021, issued from the Joint Secretary to the Government of Assam Fishery Department regarding permission for digging number 163, 62, 63, 64 Khandajan, Sidli and Gatwa Group Fishery in Morrigaon district. Also perused the joint inquiry report of Circle Officer Mayang and the District Fishery Development Officer Morrigaon and the technical report submitted by the District Fishery Development Officer Morrigaon. There is no objection from the District Authority of Morrigaon District for digging the so and so group fishery land measuring 22 bigha dry portion due to siltation out of 47 bigha 4 katha 5 lesa under Mayang Revenue Circle. Subject to the following terms and conditions, the exercise should be carried out under supervision of District Fishery Development Officer Morrigaon. In case the lessee wants to dispose of the dug out sand by sale, they should deposit royalty to the Forest Department as per procedure. Besides, the lessee should submit undertaking to the effect that they will not claim any relief in future like remission extension on the plea of expenditure in carried for digging the fishery. So, my lord, as per estimate of the fishery department, we invested 22 lakhs by employing JCB. By removing sand, we made it fit for breeding of the fishery. So practically, we have got only 2 months. After NOC issuing by the district authority, that is on 15/3/2023. So at the threshold of expiry of the extended term, the term would be expired on March 2023. District administration issued NOC only on 15/3/2023. So practically, we have got only 2 months. We employed JCB and removed sand, develop the fishery, making it fit for breeding. So generally, from April to July, it is the breeding season of fishery. Now it is fishing season. So at this time, if we deprive, we are the fishermen, we are poor fishermen. So our means of livelihood is the fishing. So we invested 22 lakhs. So just to make good the loss, we
Your lease expired on 21/5/2023. isn't it?
23. So my lord, just a minimum short period, my lord, we pray for short period just to complete the fishing. My lord, it is a government property. Therefore, what happened, my lord? We approached the government to make some extension for fishing. Thereafter, my lord, on my lord, page 54, government, my lord, by its letter dated 6/6/23, my lord, page 654, type copy, directed the director of fishery, my lord, to make an inquiry. Here it is clearly stated, my lord, page 55.
Yes. Yes.
Based on based on above, government granted permission for digging the fishery by the lessee society at its own cost White government letter number so and so dated 10/3/2021, the ADC Moringa accordingly issued NOC to the lessee society to carry out digging at their own cost on condition laid down by the government letter order dated 15/3/2023. That is the NOC issued by the district admission. It appears from the submission of the lessee society that they have carried out the exercise of digging the fishery by incurring total estimate at the cost of rupees 22 lakhs in 2 installments. It further appears that said shielded portion of the fishery measuring 22 bighas have now been made fit for fish breeding, but it will take some more time to make it fully operational for commercial fishing. The present status of the fishery has been made by the lessee through its own effort with due permission from the authority by spending a huge amount of rupees 22 lakhs. In this connection, provision of Rule 8 Clause B subclause 2 of Assam Fishery Rule 1953 may be referred to, where it is stated that state government may extend the period of lease of a fishery on the recommendation of the Director of Fisheries Assam with an intending pisciculturist who should invariably be the sitting lessee. We are sitting lessee, who agrees to such extension at revenue fixed by the government and such other conditions as may be specified by the government. In view of the above, you are requested to cause an inquiry through District Fishery Development Officer Moringa and submit report to government with your views, comments thereon, whether the proposal can consider.
Yes, what happened after this?
Thereafter, my lord, when the matter is in progress, the private respondent, he filed a writ petition before this honorable court. And my lord, stating that my lord, society has already been extended for 3 years, so further extension is not required. My lord, thereafter, my lord, this honorable court, my lord, page 63, 64, 65, 66, 67. By citing the decision of this honorable court in Joydeep Das, this honorable court, my lord, observed that paragraph, page 67, paragraph 9. Insofar as the prayer made in this writ petition is concerned, it prima facie appears that the lease period of the original 7 years lease granted for the fishery referred above to the respondent number 7 had expired on 21/5/2020. Paragraph 9, madam.
Yes.
The lease was extended on 27/20 for a period of 3 years with effect from 21/5/2020, which has expired on 21/5/2023. Therefore, the unhesitant view of this court is that the natural consequences of expiry of the extended period of lease would be to put the fishery to a fresh auction or sale. Therefore, this is a fit and proper case where the Director of Fisheries as well as Joint Secretary to the Government of Assam Fishery Department, respondent number 2, is directed to take a decision as to whether there is lawfully any scope for an extension of lease in favor of the respondent number 7 and or whether it could be lawful to put the fishery into sale or auction. The decision in this regard shall be taken within an outer period of 10 days from the date of service of the
Yes.
order. So, my lord, here, my lord, it refers to Rule 8 of the Assam Fishery Rules. So, may I cite this rule?
Yes.
Rule 8, settling authority. My lord, clause B, extension of the term of lease, where the period of lease of registered fisheries being ordinarily not less than 3 years is interfered with due to any unnecessary cause or for any unavoidable reasons beyond the control of the lessee, government may extend the period of such lease supported by official reports as to the nature of cause in exceptionally special cases for a reasonable period so as to enable such lessee to make good the loss. So here, my lord, after settling with the fishery with the society for a period of 7 years, it is a fact government extended another 3 years. But during that extended period, my lord, we could not fish the fishery as because due to that fishery was covered by river Seine. So for which we have to approach the government on many occasions. Lastly, NOC was issued only on 21st of March 2023. So only we got 2 months. So that's why, my lord, we approached the government for a short period, my
My
lord.
lord, first of all, the period of extension, my lord, for the period of 3 years after expiry of the lease.
That will be considered only after a report, isn't
My
it?
lord, that has been considered and extension
repeated.
was given up to my lord 21/5/2023.
Okay.
My lord, the permissible limit of extension has already expired. As per my lord, rule 8B, extension could be given for a period of 3 years maximum and not more than that. And in fact, my lord, there are so many judgments of this honorable court, my lord, the extension shall have to be, my lord, granted only in a, my lord, extraordinary circumstances. Your lordship may kindly see rule 8B again, my lord.
You've been running the fishery for more than 10 years.
And yes,
My lord, we
more
have
than 3
admitted,
years
my
after,
lord.
my lord,
Initially for 7 years, thereafter extended for 3 years.
3
During this extension period, my lord, we could not develop the fishery due to most of the 22 bighas out of 47 bighas of fishery
whatever
land
may
was
be the
covered by
condition,
fishery.
my lord, yeah, it is
That
the
should be looked into, my lord.
established principle of law, my lord. And laid
Nowhere
down,
stated about 3 years, my lord. In rule 8 of the fishery rules, it is not mentioned about only 3 years. Here, my lord, I would like to interfere. Rule 8, my lord, B then, my lord, clause 2, lordship will find. Clause 2 also stated that.
Where are the
state-
rules? Where are the rules?
fishery rules,
Fishery rules.
Assam fishery.
The Assam Fishery Rules 1953.
It's not available.
Lordship may take my book.
Yes, rule.
Rule 8.
Rule 8B.
Yes. Yes.
Then lordship may kindly see extension of the term of lease, where the period of lease of registered fisheries being ordinarily not less than 3 years is interfered with due to any natural cause or for any unavoidable reason beyond the control of the lessees. Government may extend the period of such lease supported by official report as to the nature of cause in exceptionally special cases, my lord, for a reasonable period so as to enable such lessee to make good of the loss. That has been done, my lord.
So initially it's 3 years.
Initially, my lord,
Initially
this
7
period was
years.
7 years, then 3 years has been extended to the petitioner. That period is also over on, my lord,
21st.
21/5/2023. And the honorable court held that the extension of lease or whatever may be, my lord, can be done during the period of, my lord, lease, not after expiry of the lease. If your lordship, my lord, peruse paragraph 15 of the 2007 4 GLR 2013, it is laid down that after expiry of the lease, extension is not possible, not permissible. Extension of lease is permissible only during the period of the lease. And in this case, my lord, the lease period has already been over on 21st of May 2023. And thereafter, my lord, it cannot be possible, my lord. It is not permissible as per the law laid down by the Sonarpur.
So what is wrong with the order?
My lord, the district authority has not
District
filed any
authority has
affidavit
already taken
as
the
to why
position on
the NOC was
19/7/2023.
issued at such belated stage after 2 years of passing the order by the government. No affidavit has been filed by the government stating the reason why the delay has been made. So, my lord, we are poor fishermen, my lord. Only practically we have got 2 months. My lord, on principle of natural justice, lordship may kindly consider our prayer is not for extension of longer period, only for a short period, just to complete the fishing, my lord. It is a government property, my lord. After all, it is a government property. We should
Order has
not
been
have.
issued 19/7/2023, isn't it? Have you got a copy?
Mhm.
Have you furnished a copy?
My lord. Copy has been furnished to the secretary of the petitioner society, my lord. In serial number 7.
No, my lord. My lord, we are still in possession, my lord.
No, my lord.
Although this order was issued, my lord, but we are allowed to continue, my lord.
Even assume for a moment.
We
my
are
lord,
allowed to
that they have
continue, my lord.
taken
That's why, my
that
lord, we
cannot be
approached
done,
before
my
your
lord.
lordship. My lord. This letter I have got, my lord.
Law laid down by this honorable court. I would like to, my lord, rely 2007 4 JLR 231, paragraph 15.
Yes.
My lord, books is not available at present, my lord. My lord, lordship may.
My lord, my humble submission.
Jailer.
My lord, my humble submission would be, my lord, this
Jailer.
letter I have got, my lord.
Jailer.
Although this was issued, but we have challenged the order passed by the government. that-
Sharma, you bring those books.
My lord.
Sharma, you bring those books.
My lord.
First, I'm gonna read
And
it.
another, my lord, here, my lord, page 66.
On request made by Mr. D.K. Shamal and additional senior government.
It will be challenge question of 1370.
First December.
1st December. Of lord.
First December, my lord, I'm going to Nagaon due to my mother's annual sadhya, my lord. First, second, and 3rd December, I will be absent, my lord. Thereafter, my lord.
Second and third.
1, 2, 3 December, my lord, I will be absent, my lord, due to my mother's annual sadhya.
6th.
My lord, I should be protected, my lord, during
No
the
protection.
Of lord.
Item 28.
May I please your lordship, my lord. Now we have come, my lord, before this noble court by way of preferring this writ appeal. Only on limited ground, my lord, because the order was passed, we are not aggrieved by the entire order, only part of the order we are aggrieved. My lord, a joint writ petition was filed by, my lord, as many as 25%. And court has, after hearing the matter in the motion stage, so my lord, motion hearing, don't disturb. And after motion hearing, my lord, court has come to the conclusion that writ petition, so far as the writ petition number 1 to 24 are concerned, not maintainable. Because different cause of action, different relief, and petitioners are working in different departments. But my lord, this particular observation of the court, my lord, while issuing a direction to the register to delete the name of petition number 2 to 24, 2024, and my lord, file different petition. My lord, we are agreed by that part of the observation of the court. Basically, my lord, law was laid down by this honorable court saying that if the cause of action is common, an order issued by the authority is common order, and both the petitioners are all petitioners are, my lord, standing on, my lord, situated on similar and equal ground, then, my lord, it is not necessary to file separate petition. Court said, even assuming that some of the petitioners are having, my lord, different cause of action or different relief sought for, and their grievance is different. In that case, we are supposed to pay only the court fee. Separate petition is not maintainable. We have annexed, my lord, lordship, kindly come to, my lord, the order dated, my lord, passed by this honorable single judge at page, my lord, 265. We have, my lord, also put at the relevant portion of the order.
Yes.
Yes, madam.
My lord. Para 5. At page 276. Considering the above, it is seen that cause of action is not same, and one with regard to petitioner. As such, the registry shall delete the names of the other petitioner, that is petition number 2 to 25, enabling them to file individual writ petition with regard to their claim of stepping up of their respective scale of pay as per ROP Rule 2017. Now, background of the case is that, my lord, all the petitioners are holding the post of senior assistant. They were given promotion prior to cutoff date. Cutoff date is 1/4/2016. The private respondent number 21 was given promotion after the cutoff date. Then ROP rule says, my lord, if the senior is not getting the equal pay scale, my lord, junior is getting higher pay scale, then in order to bring a parity in the pay scale, the person, my lord, who were promoted prior to cutoff date, they shall get equal and identical pay scale. And in terms of that, my lord, particular rules, Finance Department also issued notification to examine the matter and take appropriate decision. Accordingly, order was issued, giving us, my lord, equal pay scale. Then by a common order, that order was withdrawn. Therefore, basically, all the petitioners are similarly situated. And they are agreed by a common order, common decision.
Para 3.
Yes. Para 3 of the order. The claim of the petitioner are also different. That is, my lord, I think, my lord, with due respect, my lord, this is perhaps, my lord, it is a communication gap on my part. I could not make the court to understand or court misconcept. How can the cause of action be different? We are agreed by a common order. Because whatever benefit was given to us, that was withdrawn by a common order. And this is the common cause of action. And even assuming that the cause of action is different, then law laid down by full court of this noble court says that they have to pay a different court fee, separate court fee, this much. Question does not arise to file separate writ petition.
Para 2.
Yes, yes. There is the, my lord, observation made by the court. 25 petitioners herein are senior assistant, having under the deputy commissioner, so and so. Actually, the petitioners are serving under different establishment. How? How can it be said to be a different establishment? We are all under the district establishment, under the control of the deputy commissioner. We have been posted in different branches, subdivision and, my lord, official my lord, sub-deputy collector. Therefore, there cannot be a different establishment. Rule says, Lord, can you see, my lord? I will refer to Rule 2. What is the definition of the term establishment? We have also an extra question. Rule 2, sub-rule 4. What is the definition given? District establishment means, and it includes all non-gazetted minister staff. We are all minister staffs. Page 104. We have annexed at page 104.
Yes.
Yes, ma'am. I'm reading once again. The district establishment means and includes all non-gazetted ministerial staffs in the offices of deputy commissioner, subdivisional officer, sub-deputy collector, and block development offices of the district. And note, the offices of deputy commissioner, subordinate officer shall include branches like supply, textile, election, revenue, branch, development, etc., etc. Therefore, my lord, we are all, my lord, working in different branches and in different, my lord, subdivision. under the same establishment. Therefore, this is altogether not, my lord, the correct factual situation. What observed by my lord in para 2, that we belong to a different establishment. This is not correct.
Continue reading.
Which one? my lord?
Para 2.
Para 2, yes. Kachat. Again, once again, I'm from beginning, I'll read my lord. The 25 petitioners hearing are senior assistants serving under the Deputy Commissioner Kachar, Shilchar. Actually, the petitioners are serving under different establishment of Deputy Commissioner Kachar, Shilchar, like establishment of branches, Kachar, Shilchar, land acquisition branches, Kachar, Shilchar, Lokhipur subdivision, Lokhipur, Shilchar, Kachar, election branch, Kachar, etc., etc. Then we'll skip over. Then my lord, next page. My lord, under the 3 different treasury officials of the Kachar district, and they are Shilchar, Lokhipur's sub treasurer, new Shilchar, the petitioner have joined together against the order of personal accounts section of Deputy Commissioner Kachar, Shilchar, issued on 4/5/2022 under memo number so rejecting the stepping up of pay as per the revision of pay scale 2017, giving effect from 1/4/2016 by paying court fee for only one petition. This is the position. Therefore, my lord, there is
So
no any.
you have paid court fee for only one petition.
Pardon, my lord?
You paid the court fee for only one petition, correct?
Yes, my lord. And whether, my lord, whether it is at all necessary for each of the petitioner to file individual writ petition, or we can join together and file a common writ petition. Now, what is the law about? My lord, law should kindly see, I have annexed all the 3 judgments. There are 2 conflicting judgments. Ultimately, matter was referred to full bench Chief Justice to constitute a full bench, and law was laid down.
Then we'll consider some other day.
Pardon, my lord?
Not today.
My lord.
Notice has gone.
No. Lakshmi, better, my lord, issue notice. Because it is a question to be, my lord, adjudicated in terms of full court decision, whether, because it will have a far-reaching impact.
Who appears?
I appeal for respondent number 1, 2, and 3. But my lord, the copies have not been served in for respondent 1 and 3 to us prior to filing at the court. And the names are not reflected. At least, my lord, the order may be there that, my lord, SC GAD may be reflected in the court.
No.
1, 2, and 3 I'm appealing.
The Google standing counsel GAD. Yeah. 1, 2, and 3. The standing counsel accountant general appeals for respondent 4. And Mr. And thus the government advocate is for respondents 5 to
and 13 to my lord, 13 to 20.
Treasury I'm appealing, man. 17, 18, 19, 20.
1 minute.
13 to 16.
1 to 3.
13 and 14.
13 and 14. You are appealing for Google?
My lord, 1 to 3, then my lord, 17 to 20.
17 to 20.
This is there, my lord. Section.
Access to India.
How about the other respondents?
For excise, my lord, there is standing document.
Excise.
That
That is 16, is it?
Yes, 16.
Any other excise?
Only 16.
Is the private.
Election officer?
21 private.
Election officer. Yes.
Okay, that's for 1 to 11.
Oh, my lord, 5 to
No, no, 1, 2, 13. Oh, no.
5 to 15.
5 to 14. 5 to 14.
Food civil supply.
Wouldn't say 5 to 15.
Yes,
5
5 to 15.
The council for the appellant shall furnish copy to the standing council exercise within the course of the day. So,
Now, my lord, 2 days time, my lord, huge petition, where to get it? Yes, yes, we'll provide.
appellant
2 days time may be granted, my lord, because we have to get it.
within 2 days from today. Appellant to take steps for service of notice on respond 21. By the resident complainant.
My lord, may I pray that, my lord, because my lord, writ petition is standing. And if my lord is, it court proceeds, my lord, then it may create some problem, my lord.
I'm not staying the order.
Otherwise, that petition will, my lord, proceed.
Let it proceed.
Then also, my lord, I may be given the liberty to renew my prayer for stay on the next returnable day.
Therefore, interim shall be considered on the next week.
Next day returnable.
SCGAD may be reflected in the call.
Registry is also directed to reflect the name of the standing council SC GAD in the process.
I will like.
My lord, Lordship kindly, my lord, fix the matter, my lord,
You want
give
the
it- by
date?
giving a suitable date.
Please,
Subject to convenience of this court, my lord. Before, my lord, coming and showing vacation,
21st.
my lord. Oh, 21, I will not be, my lord, I will be out of state. 17, 18, 19, many days.
You have to take steps on respond 21 by registered post. At least
Oh.
4 weeks is required, isn't it?
Oh, yes, my lord.
So it has to go
Then,
to New
my
Year.
lord, my lord, then, my lord, on reopening.
It's on 8 January.
8, my lord. I'm grateful, my lord.
Item 29.
Is your lordship here I'm aggrieved by refusal to grant the interim order by the learned single judge. Lordship, what happened? I am a pharmacist, a bunch of us actually. We are pharmacists. We had our first registration under the Pharmacy Act in different states like Nagaland, Bengal, Bihar, etc. Then we came to Assam. We surrendered our first registration as required under the law, and we were registered in Assam. In the Assam Pharmacy Council registered us. Our names were entered in the rolls, and we carried on our business of pharmacy. And then, Lordship, in 2013, our registrations were renewed from time to time. After 2013, the government of Assam, the Pharmacy Council stopped, and we filed writ petitions. A number of writ petitions were filed, and this honorable court was pleased to set aside the cancellation and gave a detailed order on how this matter has to be dealt with, how we must be given an opportunity of hearing, show cause, etc., and how we should be allowed to place our matters. Everything was detailed there. But despite that, what happened, and then the date for filing our application, putting in all our papers, was fixed on 15/5/2019. So we filed this batch of appellants, filed our applications within time with all our papers, and we were given the acknowledgement also. Thereafter, Lordship, nothing happened on that. We were issued a show cause notice that your papers are cyclo-style show cause notice to everyone. Same show cause notice was issued to everyone. We replied to the show cause notices saying that we give our papers way back with our application. We surrendered our first registration from the original state at the time of getting the second registration as required under the Act, and we gave everything, we complied with everything. Thereafter, Lordship, without giving us any hearing or anything, the impugned cancellation orders were passed. Lordship, I may take just one of the cancellation orders. I may refer for the convenience of your Lordship, one cancellation, that is at page 408, Lordship. I think that would really explain it. page 408, annexure 106. With reference, has Lordship got it?
Yes.
With reference to this cancellation of notice under section 36(1)(1) of the Pharmacy Act. With reference to the above, I am to inform you that the registration number this has been cancelled permanently under 36(1) with 1 of the Pharmacy Act 1948 and removed your name from the Registrar of Assam Pharmacy Council as you have failed to submit any relevant documents justifying how your qualification to substantiate your eligibility to the registrar as pharmacist in terms of section 31A or 31B or 31C or 31D of the Pharmacy Act and in terms of the order passed by the Honorable Guwahati High Court in case number this and this. This has reference to the Executive Committee resolution dated 7/8/2022 and confirmation by the State Council under section 36(3) of the Pharmacy Act. Now, what has happened, Lordship? If I may just take your Lordship to the Pharmacy Act, this has been passed in a most mechanical order, same order to everyone. And without giving us a hearing, that apart, Lordship's 36 of the Pharmacy Act deals with removal from registration. 36(1) says that subject to the provisions of this section, the Executive Committee may order that the name of a registered pharmacist shall be removed from the registrar where it is satisfied after giving him a reasonable opportunity of being heard and after further inquiry, if any, as it may think fit, make that his name, I'm concerned on 36(1), that his name has been entered into the register by error or on account of misrepresentation or suppression of material facts. This is under 1 I've been removed. Now, Lordship, 36(1) does not end there. Section 36 also has another subsection that is 36(3).
Yes.
36, it has another subsection 36(3), which provides that an order under subsection 1 shall be subject to confirmation by the State Council and shall not take effect until expiry of 3 months from the date of such confirmation. So the order of the Executive Committee has to be confirmed by the State Council. And after 3 months, it will take effect. Then Lordship will come to 36D. A person aggrieved by an order under subsection 1, which has been confirmed by the State.
36D.
36(4). Next page. A person aggrieved by an order under subsection 1, which has been confirmed by the State Council, may, within 30 days from communication to him of such confirmation, appeal to the state government, and an order of the state government upon such an appeal shall be final. Now, what has happened? The confirmation by the State Council and the order of the Executive Committee was never forwarded to us before passing the cancellation order. So our right to appeal has been totally blocked and we have been denied of that valuable right, a statutory right which has been given to us. Lordship, a bunch of us had come to approach this Honorable Court by filing writ petitions, and in those matters, this Honorable Court was pleased to grant stay in the interim. Lordship, I'll just take Lordship. I think the last order would. Yes, Lordship, I'll just point at this one order. If Lordship looks at page 447, 446, actually, 5.
Oh.
Page 44, the relevant portion is at page 450. 451. Lordship, these are the interim orders which has been passed in respect of people similarly placed with us, absolutely similarly. 444 and the relevant part is at page 441.
441.
451, sorry. Accordingly, the operation of the impugned order at the last page. Accordingly, or operation of the impugned order dated this under the various serial numbers passed by the Assam Pharmacy Council shall remain till the next date of next year listing. So these interim orders were passed. Now, in my case, neither interim order has been passed by the single judge, nor have a notice been issued on the interim claim. In the effect is that my business, that is my means of livelihood, has come to an end, to a halt, even before my matter is decided. A matter in which actions have been taken against me, flouting this honorable court's direction, flouting the provisions of law, but yet I have not been granted an interim relief.
Where's the impugned order?
My interim order. 482, Lordship. This is my petition, Lordship. .482 is the relevant is the order. Lordship will find Mr. Gogoi appears for the accept notices on behalf of all the respondents. No notices need be issued in respect of the respondents. The learned counsel for the petitioner shall serve required number of extra copies of the petition along with annexures within 3 days. List the case after 3 weeks from today. Lordship, I have not even been issued a notice on my interim order.
Your interim has not been rejected.
Not rejected, neither considered.
You can renew it on the next returnable date.
Lordship, the point is, what has happened is that nor has a notice been issued. It was not considered at all.
No, notice is issued.
Notice only on the main case, Lordship, not on the interim.
In any case, you can renew it because the interim has not been rejected.
Yes, Lordship. So 2019 has been listed after that. It has not even been listed after that, Lordship. So my prayer is let the single judge consider my interim on the next.
But we cannot direct a single judge to consider it. You can renew your prayer for interim.
I can, but I'll have to file a fresh, because what happened, and in the interim, Lordship can always say they ask a single judge to consider, because other matters, there has to be a parity of judicial decisions. A bunch of us get protection. I am singled out. Bunch of us have got protection of an interim. But I am being my lot has been singled out. I have not got the protection. I am out of business now, Lordship. Out of business, out of livelihood. Lordship sitting, the Honorable Division Bench can always grant me an interim and send the matter back to the single judge.
You can. Here, there's no rejection of the interim. Was it rejected?
No, my lord. In fact, my lord, they were asked to, my lord, place before his honorable court to any document whereby they can satisfy the honorable court that they fulfill this criteria under section 31. Be that as it may, my lord, since they have approached this honorable division bench, Lordship can, my lord, close this writ appeal, giving liberty to the petitioner, the appellant herein, to renew their prayer for interim. Whenever the matter is listed before a learned single judge, that observation can be closed.
Or Lordship can allow us to go on appeal before the state government. Under
yes,
33, I have no problems with that also. Lordship can allow us to, because 36
subsection 4 of
36 gives
they
us
have a statutory right of appeal.
appeal. So let us go, and in the meantime, they will provide me the order of the executive committee.
So that, my lord, statute nowhere prescribes that, my lord. That
Against what will I appeal?
Against the order of cancellation.
No, order of cancellation. No, Lordship. I can appeal against the order of the state or executive committee confirmed by the state council.
Let us read it again, remove.
Yes, an order made under subsection 1. Subsection 1 is the order made by the executive committee. Executive committee may order that the names of this may be of a registered premises shall be removed from the registrar where it is satisfied that after giving him a reasonable opportunity of being heard and after such further inquiry, if any, it may think that his name has been entered into the register with error or on account of misrepresentation or suppression of material facts. This is how. Then Lordship will come to 3. An order passed under subsection 1 shall be subject to confirmation by the state council and shall take effect and shall not take effect until expiry of 3 months from the date of such confirmation.
So state council has
to confirm.
has it been confirmed?
Yeah, this has been confirmed. I have no copies of it.
21, 23.
It has been confirmed. And then, Lordship, a person aggrieved by an order under subsection 1, which has been confirmed by the state council, may within 30 days from the date of communication to him of such confirmation, appeal to the state government, and the order of the state government shall be final. Now, Lordship will look at the cancellation order. That is not an order against which I can file an appeal. It is an order communicating the cancellation. It's a communication, not a order. I have to appeal against the order. To say that I have to appeal against it, it's really foolish. 408, Lordship will find, with reference to the above, I am to inform you. 408. Has Lordship got it?
Yes.
With reference to the above, I am to inform you that your registration number this has been cancelled permanently under subsection 1 of the Pharmacy Act and removed your name from the registrar of Assam Pharmacy Council as you have failed to submit the relevant documents justifying your quantification to substantiate your eligibility to register as pharmacist in terms of section 33(1)(a) or 33(1)(b) or 33(c) or 31(d) of the Pharmacy Act in terms of order of the Honorable Guwahati High Court number this. This is reference to the has a reference of the Executive Committee resolution dated this and confirmation by State Council under this. So this is what I'll have to appeal against, not this communication. This communication doesn't give me anything. And Lordship will find that my registration is under 32B. Under 32B because I have come from another state, not 31. The very conception of the Executive Committee is wrong. They assume it I come under 33(1), but I get qualification because it's a subsequent registration. It's not a first registration. So I come under 32B. So entire basis is wrong. My first registration was elsewhere.
So the confirmation.
Yes.
That has not been given to you.
No. The Executive Committee order has not been given to you. What do I appeal against? Let them give those.
Executive Committee has not been given.
Even that resolution and the confirmation of by the State Council.
That has not.
No, nothing. Let them give me those.
Furnished copies.
They let them copy.
Difficulties, my lord, presently the pharmacy, Assam Pharmacy Council is not functioning. My lord.
So wonderful.
Because the committee has been dissolved. They have completed the tenure. No election has now been held. And the registrar has also retired.
When was their license cancelled?
It was in
23.
No, subsequent to the cancellation license.
No, my license was cancelled in 23.
4/5/23.
Yes.
Then
thereafter the tenure is over.
Prior to that, there should be
no. I am not saying that, my lord. There is no such official to even furnish instruction to this honorable court. There are some office bearer, like the my lord, junior assistant and all. They, my lord, they have no authority, my lord, even to furnish some inspection to us.
So in the bargain, no matter whatever illegality has been done to me, I lose my means of livelihood and they say we have no one. What is the state of affairs, doctor? Is this?
And my lord, regarding my lord furnishing of this copy of the executive committee resolution dated 17/8/2022.
Where is that?
No, it's mentioned in the my lord impugn order cancellation at page 106 of 408. Petitioner submits that the appellant submits that my lord they will have to challenge this particular resolution number 6 dated 17/8/2022. So they
Where is
need
that
to-
resolution?
the last my lord last para.
Executive
At the
committee
same-
resolution.
Yes. Number 6 dated 17/8.
3 months.
In this regard, my lord, lordship will give them liberty to prepare a appeal and my lord, they
Against
will
what?
approach the my lord.
No,
No, they will
against
approach
what?
they will approach the Assam Pharmacy Council for a copy of this and they will furnish it.
Who's not sitting?
I am not here, my lord, to furnish copies to the appellant. my lord. That two of these
No,
resolutions
no, I'm
and all.
asking you, I'm not asking you to furnish copies.
Yes, they will approach.
Who-
Lordship may
who-
indicate in the order.
Who is going to furnish them the copies of the?
Well, they will
executive-
decide, my lord.
executive
They will
committee
decide.
And
They will
the,
decide. The pharmacy-
and the state council?
No, they will approach the Assam Pharmacy Council, my lord. They will furnish it. Lordship will indicate in the order so that they can prepare an appeal. Lordship will indicate in the order.
And it's defunct, supposedly.
You said it's defunct, isn't it?
As on that, it is not functioning, but there are office bearers. Let them decide how they will furnish, they will furnish. I cannot, my lord, as a council, my lord, today, whatever is there, I am
I'm
submitting
not
it.
asking you to furnish as a council.
Lordship.
I'm just asking you whom they will approach.
No,
when
they
the-
will.
When the council
My
is
lord, there
defunct.
is, as on that, there is a office. There is a office. So let them approach there. Lordship will give the liberty that moment they approach, they will have to be furnished.
Okay.
Then they will prepare.
And
an
lordship, then till such time, this order will be kept in abeyance.
So that they can renew, my lord, before the appellate.
No, that way, when the officer is not sitting, please be reasonable. Talk like a person. You're dealing with
There is no
human
question
beings.
of being reasonable here. The appellants are before this honorable court will decide.
Court will
How
decide,
can
but
I be reasonable?
But
my lord?
Jonas M. Hazarika, the senior counsel,
That is ridiculous.
is someone on counsel for the appellants. Stop. Also heard Mr. V. Gogoi, the standing counsel, health department,
Health department.
for the respondents.
Yes, ma'am.
Stop. Para. The appellants hearing were earlier issued pharmacist license. Stop. However, by orders, all the same date?
No, so lots of various different
Will
dates.
indicate the-
From 4, 5, 28, 5, 5, it's all various dates, lordship. 28, 4.
Give me the dates.
He'll give the list of dates.
However, by orders. Dated so and so.
Not orders, lordship, cancellation notices actually.
No, these are
However, cancellation notice.
Yes, cancellation notice.
Dated so and so.
They're not orders.
Issued by the registered
Please read.
secretary. Assam Pharmacy Council. The registration of the appellants were cancelled.
They were informed, that's the information.
Were informed about the cancellation of the registration. Stop. The being aggrieved. The appellants approach the learned single judge by filing WBC number
WBC PSC.
5335 of 2023. Stop. The learned single judge issued notice on 29/2023, making it reasonable in 3 weeks. However, the prayer for interim was not considered. Being aggrieved with the order dated 29/2023, inasmuch as the prayer for interim was not considered, the president stopped. But after hearing the learned counsel for the parties, instead of keeping this writ appeal pending, this appeal is accordingly disposed of, directing the appellants to approach the who?
Here, my lord, the.
I have to,
office of the registrar, my lord.
officer register, the
No.
pharmacy council, lordship.
The office of the office of the Assam Pharmacy Council. for issuance of copies
Yes,
of
the
the
executive committee
executive
resolution
committee resolution.
dated
Number 6, my lord.
number
Dated
7/8/2006,
executive committee
2022.
resolution within bracket 6.
Lordship will indicate the number also, resolution number 6
Yes,
dated
it-
17/8/2020.
And
And
confirmation
confirmation by the state council. under
Dated
Section 26 within
3
bracket 3. of
dated
the Pharmacy Act 1948.
dated 21
On 21.
2023.
On receipt of the same, comma. The appellants are given liberty to file an appeal before the
Government.
before the
State government.
state government within a period of 30 days from the date of receipt of the copies of the executive committee resolution and the confirmation by the state council. With the aforesaid directions, this writ appeal is disposed of.
Lordship, till such time I'll be my cancellation orders shall be stayed.
That again will be one.
No, everyone
them
is stayed. Let everyone has
Let
been
them
stayed.
approach, ma'am.
Are they are not there? Where do I approach? He'll not give me till such time, till my appeal is disposed of. I'm not asking for anything more. Lordship, it's only fair because some people have already got it. Got a stay.
Till the copies of the resolution of the executive committee and the confirmation by the state council is furnished to the appellants. The imputed orders of cancellation shall remain suspended.
Obliged.
Item number 36, my lord, admission matter, medical admission matter, my lord. And it was
One more thing, Lordship, may add that they will approach the authorities within a period of 1 month. Otherwise, they will not approach, and my lord, this interim will continue.
Shall approach the Assam Pharmacy Council. or
Within a period of
The
7
office of the Assam Pharmacy Council within a period of 2 weeks. from today.
No, approaching the.
To approach
council.
the council for receiving copies within 2 weeks.
my lord, item number 36, my lord, the medical admission matter, it was my lord, judgment was reserved. Now the note has come before Lordship, my lord, that it has been released, my lord, as per the note, my lord. So matter may be listed for admission hearing, my lord, on 30th of November, my lord.
30.
This
30th, my lord, some
30th.
difficulty, my lord.
Some
on our side.
difficulties are there.
Let it be on 7th of.
Or 3rd of December.
List the matter for admission hearing on
7th of December, Tuesday,
7th of December.
Thursday.
Lordship, my stay may be till the decision of the state council. That has to be within 1 month again.
No, my lord.
Yes, don't be so be merciful till the decision of the state council.
I'll correct it. Keep a copy here.
Lord, I'd like to mention item number 3, Milords. It's a matter for orders. Milords, it's a peculiar matter,
Item?
modification, 43, Milords. Relates to a foreigners tribunal matter. The LCR has disappeared, Milords, from the registry of this honorable court, and it's a dispose of writ appeal. If Milords would kindly take it on 1st or 4th of December, Milords. Friday or Monday, 1st or 4th. 4th of December, Milords.
Okay. List this matter on 4th of December.
Grateful.
Lordship's permission, item number 40, if it could be taken up, my lord, sometime on the 1st or the 4th, my lord.
Okay, 40.
Item 40, my lord.
Okay, and request made by our Mazuga and for the appellant.
Appellant.
List on. How about 6th? 6th December.
Obliged.